Hi, everyone. Thank you so much for coming to this lunch event. My name is Mackenzie Krause, and I am the editor-in-chief of Law and Inequality, a journal of theory and practice. As our name suggests, our journal publishes a lot about how the law fails to address inequalities in our system, even when it's intended to do so. And mass incarceration is obviously a huge issue in this area, so JLI wanted to come in and help with this event. So we'll begin and have each of the panelists introduce themselves, and why don't you guys say a little bit about your background and your experience in relation to this issue.
Good afternoon. My name's Tanya. I'm an Indigenous woman. I'm a revolutionary mother, and I am an incarceration survivor. I spent about 25 years of my life in and out of the court systems, jails, prisons, probation, parole, and even further back if you want to bring in the foster care system, which we believe is a direct correlation to mass incarceration. Right now, I can just kind of go into who I am now. I work with the Minnesota Prison Doula Project. We support birthing people who are incarcerated. I am a 2019 Soros Justice Fellow, and my project is We Rise. It's a leadership collective of formerly incarcerated women shaping and creating policy and systems change with a restorative, transformative, and healing justice lens. We believe that those that are directly impacted are the ones that are going to be the ones that find our liberation in partnership with our allies. And those allies can be take many different shapes, and we're finding that they can even be the system that has been oppressing us. It just depends on who's in that leadership. I also am the executive director of the Minnesota Freedom Fund. That's our community bail fund in Minneapolis and St. Paul. And to date, in the last year, we've been able to free about 300 people from the criminal side and about 24 from the immigration side. And stay tuned because you're going to see a pretty amazing event that's happening on Wednesday that's really exciting. Trying to think I'm also a part of the Minnesota Sentencing Guidelines Commission, so I'm the first formerly incarcerated person to sit on that commission. It's very nice. A lot of work, a lot of things that I didn't think I would be interested in doing, but it's paving a way for more directly impacted leaders. Also, at the first of the year, we are opening up the first women's reentry house in Minnesota, and it's going to focus on reentry and reunification for women coming out of incarceration. In Minnesota, there's 37,000 women that are coming out of incarceration every year, and right now there is no supports for them specifically, or anything to reunite them with their children. So that's who I am. I'm going to just pass it along and take it over, Ben.
Thank you. Good afternoon, everyone. Can you hear me?
Is this one working?
Yeah.
Do you want to try this one?
I think I got it. User error. All right, is that better? Thank you. Good afternoon. My name is Ben Feist. I'm the Chief Programs Officer for the ACLU of Minnesota. I bet most people in this room know about the ACLU and the work that we do, but in case you don't, the ACLU is a nonpartisan, nonprofit organization dedicated to protecting the civil liberties of all Minnesotans under the U.S. and Minnesota constitutions. We're an affiliate of the national ACLU, which also does great work throughout the country. But here in Minnesota, we're able to set the agenda on the type of issues that we feel are most important in the preservation and expanding of civil liberties here. For the previous 6 years, I was actually the legislative director for the ACLU of Minnesota. So I was the primary lobbyist at the state capitol, dealing with all manner of civil liberties issues, including criminal justice reform type issues. Over the last 6 months or so, I've transitioned to this new position, which is really an exciting one for me because I now get to strategize and integrate our litigation, lobbying, and organizing arms together so that we as an organization can do more impactful integrated advocacy. And mass incarceration is a perfect example of that, where we are constantly looking for ways to change the policies at the state level, but also work at the local level and change hearts and minds wherever possible to get the results that we need, because we know we can't simply litigate our way into everything, and we also can't just get our legislature to do the things that seem so obvious to fix our system. Previous to this, I was also an assistant attorney general with the Minnesota Attorney General's office, so I do have a litigation background as well, and practiced for a short time in private immigration law. I'll pass it on.
Hi, I'm Jana Emory. I teach here at the University of Minnesota Law School. I also direct its clemency project, which we instituted in 2014 in response to President Obama's initiative to give clemency to low-level nonviolent drug offenders. In connection with that program, we filed 35 petitions. We did ultimately get 14 grants, and 1 got compassionate release. We also worked with local lawyers, and about 15 local lawyers, some of them might be here, who also filed under that program, and they got about 5 grants through that program. So it was kind of an exciting time, but it was also disappointing because there were a lot of our clients left without relief. And since then, I've continued to file petitions. For what it's worth, it's not clear that there will be a clemency initiative by President Trump. Sometimes we hear statements that he might do one, and then the next day it seems pretty clear that he won't. But what's comforting is that all the Democratic nominees have talked about doing a robust clemency initiative if they get elected. So there's a possibility that in 2021, if we end up with a Democratic president, that there will be a more robust clemency use at the federal level. I've also worked at the state level in clemency. Governor Cuomo announced an initiative in New York, and so I worked with the state clemency program to file petitions with him. My students filed 8 petitions. Overall, the State Clemency Project submitted over 100 petitions to him. Unfortunately, he hasn't done anything on that either. So clemency is something that sounds great in theory, I think, to these politicians initially, and then when they finally start sitting down and looking at the cases themselves, they get cold feet and aren't really prepared to take the kind of that political will, that extra step, which is why I'm actually really interested in the Second Look movement, which is the idea that we actually have legislation that would allow cases to go back to the sentencing judge for a second look after a certain period of time. The Model Penal Code has introduced this incredibly unique and innovative idea in its latest iteration. It proposes the second look after 15 years. I would think that with some of the nonviolent offenses out there that we might want to start the second look at 10 years. New York is doing it even at an earlier level. It's doing it at 8 years for women who have experienced domestic violence. So ultimately, my goal with our clemency project here at the law school is to lobby for and support second look legislation and then represent people on those second look cases. Just my background, I have practiced as a criminal defense attorney for 25 years, starting out as a public defender in New York City, then a federal defender, then having my own practice, and I've had my own practice here in Minnesota since 2013, but now I'm teaching full-time, so my practice takes a back seat. Okay, thank you.
Thank you. Good afternoon, everybody. Oh, okay, thank you. Thank you. My name is Richard McLemore. I have actually a background in psychology, so I come from a little different perspective. I'm a representative of McLemore Holdings. At McLemore Holdings, we provide the ability to learn and really learn better ways to maximize your time. We do it through trainings and we do it through house continuum courses. We work with individuals, we work with communities, we work with companies doing this. However, as a contractor, I've worked with a lot of different agencies. To date, I've probably worked with about 15 nonprofits. Some of the ones I work with right now is the Minnesota Prison Doulas Project, big up. I'm a board member for We Are Criminals. Anybody out there not know what We Are Criminals are? That organization? I love that everyone's in the know. where they say 1 in 4 people have a past, oh. You good? So 1 in 4 people have a criminal record, but 4 in 4 people have a criminal past, right? We've all done something, right? All right. So I'm deeply ingrained in that organization. I truly believe in what we're doing, because the only way to right this wrong is if we look at ourselves and say, hey, I can't judge anybody because I may have done something too, right? So another organization I do some work with is the Ethos Project. Anybody Ramsey County folks here? Anyone ever heard of the Ethos program? Wow. Okay, so the quick 30-second on that is a diversionary program. It's a restorative justice tactic where we pull people out of the system before they get a record and put diversionary tactics in place through the restorative justice lens, meaning we sit folks down in a circle process and we try to right the wrong through conversation and community assistance, not locking someone up or giving them a fine. So it's a totally different way, it's a totally different way to look at retribution, right? It's kind of hard talking about yourself. Wow. Last thing I want to talk about is there's a program in Ramsey County, JDAI initiative, JDAI. I currently work with them providing a community diversion program to youth. There's not a lot of kids in the Ramsey County Juvenile Detention Center. If you go down there, there's room for maybe 100 kids. At any given time, you may only have maybe 15, right? The problem is those 15 kids are either on their way to being certified to be tried as an adult, or they're looking at like an EJJ program, which is an extended juvenile jurisdiction program. But the nuts and bolts of that is if they don't successfully complete it, everything they're done is a wash and they still have to go to prison as an adult. So the community diversion program is near and dear to my heart because the kids I'm dealing with are truly looking at things and having to consider things in their life that they shouldn't have to, because their brains aren't even developed enough to understand what they're going through. Thank you.
All right, so we'll kind of have a little Minnesota focus here. Do you think Minnesota has a mass incarceration problem? And if so, what are some of the causes?
Is this a trick question? No, well, we look at, of course we do. We may say that we boast that we're one of the lowest, have some of the lowest rates, but we're actually one of the states that is increasing over time, right? And other states are decreasing their prison populations. And when we look at incarceration and we look at, a lot of times it's just focused on our state facilities, and we're not looking at the issues that are happening in our rural county jails or even our urban county jails, and they're overflowing. We're building new facilities and filling those and filling more and filling more. And when we talk about what are some of the causes, racism. As a Native woman, I make up our population is less than 1% of the overall population in Minnesota, and we make up 25% in the state facilities. And in some county jails, we've seen numbers of 95% of the women are Native women. And at sometimes those same facilities have 100% Native women. We know that Native women are being, now again, I'm just gonna say because I am a woman, so this is where I focus on. It has nothing to take away from my brothers that are also incarcerated, but this is where I focus on. Women's rates of incarceration have risen 832% since 1980, and that's here in Minnesota also. In 2000, there was about 175 women at Shakopee. Now there's almost 700. Wow. So do we have an issue? We definitely have an issue. When I say that 37,000 women are coming out of incarceration in Minnesota every year, that is from the Prison Policy Initiative. So we know that those are facts, right? That's not just a number that I'm pulling from the air. Some of the other things that make up for that is we know that the prison population, and again, we're looking at women in the jail populations, is people that are, the majority of them are not people that are actually even charged with a new crime. It's technical violations or probation revocations. So that's failure to have supports in the community. That's a reason why, because we would rather put more money into locking someone up than we would to keeping them in the community and actually helping and coming around and supporting them to build a new life, to be able to have the village that they need. the core issue of why we have mass incarceration, racism, trauma, because people are going to prison for survival. People are like, what do you mean when you say that? Well, if I, again, look at women, we have, I think I looked this morning, it's 458% of the women are there for drugs. That's surviving trauma of some sort. People use drugs to survive trauma. They sell drugs to survive an addiction or poverty. Sex work. That's to survive the same things, right? And even, I really come against this violent and nonviolent, because violence is a symptom of trauma, right? And so especially when you look at women, 90% of the women that are incarcerated in the United States for murder, it's against their abuser.
Wow.
And that's not even talking about how many of them are in there for assault. So again, the core reason that people are being locked up and they're not making a choice to go out and become an outlaw. Those days are dead and gone. We're not talking about people jumping on their horse and robbing banks. What we're talking about is people surviving in this world and doing it the only way that they know how. And that's, I say with my own self that I was a drug addict. I was a meth addict. And it was the only thing that kept me alive, because I would have killed myself from the pain otherwise. So if we start to look at those issues, that's when we're gonna start to change mass incarceration.
So yeah, we obviously have a mass incarceration problem here in Minnesota. And one of the problems that I think we run into is we're often comparing ourselves against other states. And that's really problematic when you should be looking at what's going on in the whole wide world and the crazy situation that we see our country in when it comes to mass incarceration. Minnesota likes to show off on all these great statistics and standings about how we're one of the best places to live. And in some ways, I can agree with that. But usually there's the caveat, if you're white. That's the elephant in the room here. We have some of the worst racial disparities in the country here in Minnesota, and that's definitely the case in the way that we incarcerate people. So the National ACLU actually put together blueprints for smart justice for all 50 states and released these within, I think, the last year or two. And you could look this up, just Google Blueprint for Smart Justice Minnesota, and you'll see a 40-page document that gives you all sorts of amazing facts and statistics and ideas for addressing all of this. But a couple of things I wanted to point out, because I think it's important from the ACLU perspective that while we always care about what's going on with mass incarceration, it really is this racial justice lens that has most of our attention here. So based on some numbers put together by the Urban Institute and the ACLU, in 2017, they found Black Minnesotans account for 34% of the prison population, only 6% of the state adult population. Native folks are imprisoned at nearly 14 times the rate of white adults in Minnesota, and they only account for 1% of the adult population, they comprise 10%. So similar numbers there. And also Latinx folks are 4% of our state population and comprise 6% of those incarcerated. So again, we have disproportionality among several different groups here. So again, I think we have a lot of work. Where does this all come from? Obviously, in addition to the racism, I thought of a couple of specific things. Technical violations of probation conditions, right? We got so many situations with people on these long probation sentences being sent back when there's not another crime other than you weren't able to comply with those conditions. Our drug sentences are still out of control here, despite great work that was done in 2016 here to move us in the right direction. We have a failed war on drugs, and the rhetoric at the state capitol and everywhere else is still focusing on those evils and not on the reality of the people's lives, that these are conditions that need to be treated, and there are much better ways than locking people up to ultimately address that. We also have incredibly long sentences and an inability to earn time off of these minimum sentences by, for example, participating in programs and treatment while incarcerated. And lastly, again, since I'm sort of a creature of lobbying the state legislature, the legislative desire to create and expand new crimes is there every single session. There are always new crimes introduced, and usually new or expanded crimes that become law. But it rarely, if ever, are we seeing those crimes chipped away at, even when we have all of this information that it's not actually the best thing for public safety to keep those on the books.
Ben and Tanya addressed many of the issues that are the root of our problem of mass incarceration here in Minnesota, and I certainly would agree that we have a mass incarceration problem. We also have a mass probation problem. Really, the highest, one of the highest states in the country for the number of people under supervision and on parole. Luckily, there's a lot of initiatives in place now to try to cap the probationary terms that people face, because in fact we sometimes have people getting terms of 40 years probation. And the impact of probation, the impact of the constant connection with the criminal justice system, and the way that diminishes the individual's capacity to really move beyond the crime and see their life anew apart from the criminal justice system means that those long terms really do need to be addressed. And of course, we need to look at prosecutors and their prosecutorial policies, their charging policies, the fact that politics often drives the choices that they're making, and then we get an infrastructure of prosecutors following policies blindly, policies that require certain plea offers to be made and aren't open to more innovative offers, require convictions on certain counts. Here in Minneapolis, for example, prosecutors are insisting on the 5-year mandatory minimum for a felon in possession of a weapon. That is producing many incarcerations per year as a result of that offer, that refusal to plea bargain, for example. And so we have to look at every step of the system, both from the decisions to arrest, the decision to charge, the judges and their sentencing policies, and then post the sentencing, the potential for release. I did want to also highlight the kind of low-level criminal justice enforcement that goes on with fines and fees in this state. And it's again something that's producing a lot of interesting initiatives. In fact, there was just a report recently about a group that analyzed Ramsey County and its criminal justice fees and determined that at least $2 million could just be erased from the books to alleviate the pressure on the poor individuals who are struggling to pay these fines. If they don't pay the fines, their license gets suspended, then they get caught for driving with a suspended license, and they're back in court in something else, and it's just an incredible cycle of criminal, experience of the criminal justice system, a fine, and more burden on very poor people to keep their license alive, which keeps their job alive, and also pay the fees. And I just want to point out that Philando Castile, between 2002 and 2016, had been stopped 46 times and owed $6,000 in fees for these various stops. And I think that there's a lot of you in the audience today that could literally say you've been stopped once or twice in the past 10 or 20 years. So this brings in Tanya's racism point, but also just the brutal impact on people, on poor people of these that kind of low-level enforcement in the criminal justice system has a huge impact.
Cool. Thank you. I think Jana and Ben and Tanya said it all. There is one thing that I always think about. How many counties are in Minnesota? 87, exactly. There's 87 counties in Minnesota, right? Yet 72% of people that return from corrections go to what 2 counties? Yeah, exactly. All right. So there are no accidents. There's definitely no accidents. And to one thing, it's not poor because I don't consider myself in poverty. I mean, I like to think I can manage my finances and things get a little tight, but I wouldn't consider myself in poverty. Yet I get pulled over at least once a month. It doesn't matter if I'm in a suit and tie. I don't drive an old car. I actually drive a brand new car. And it doesn't matter what the statistics say. I still get pulled over at 42 at least once a month. I mean, just think about that. We're in the 11th month of the year. I've gotten pulled over at least 10 times this year. I probably got pulled over more times in this 1 year than some people's got pulled over their entire lives.
All right, thank you. Before I ask another question, just note that Rebecca is going around, so if you have any questions you want to write down on one of these flashcards, she can take that, and hopefully at the end I could ask one or two. And you could ask directly to one of the panelists or the panel as a whole. But we've heard some talk about mandatory minimums here in Minnesota, and so I was curious if any of you have thoughts on Minnesota's mandatory minimums compared to other states and what role that's had for Minnesota's populations in comparison to others. Does anyone have any thoughts on that per se?
Well, I haven't analyzed mandatory minimums here versus all other states. I would say that some of them are less draconian than I've seen in other states. They're less draconian than we see at the federal level, but we do have them. And from my understanding and talking to public defenders, they play a significant role in gun cases. They still play a role in drug cases, and they play a role in sexual assault cases. And fundamentally, mandatory minimums are just a bludgeon that fails to recognize the individuality of the person before them. It denies the judge the power to be a sentencer. It hands that sentencing power to the prosecutor. Once the prosecutor has levied that charge, then it's essentially the prosecutor is becoming the sentencer. Now, in some of these mandatory minimums, the judges have the power nonetheless on an open plea to find substantial and compelling reasons not to impose the mandatory minimum, but those don't exist in all of the mandatory minimum cases here. And the judges are often, statistically, they tend to hew towards the guidelines and tend to be, even if they would depart from a mandatory minimum, that wouldn't mean they'd necessarily depart down to probation. So mandatory minimums are exerting a role in the sentencing process and the number of people who go to prison and for how long.
All right, any other comments? Okay. We've certainly, so it's mentioned that Minnesota does have a lower than average prison population, but that it is rising. But I'm curious if, you all have partaken in something to try and help keep the populations low. So do you think Minnesota does anything differently compared to other regions? And what exactly is Minnesota doing to help reduce the population? But also, is Minnesota doing anything new that's contributing to this increasing prison population?
Let me hop in there. I was talking about the Ethos program over in Ramsey County briefly. Expanding on that, I think that's an incredible effort because what it's doing is it's putting the power back in the community's hands. It's putting power back in people's hands, And I feel like it takes community to fix a problem. Now, we can use catchphrases, but just speaking literally, it's going to take the folks that are involved in it to get out of it. It seems like we spend a lot of times bringing, and no disrespect to anybody, but we spend a lot of times bringing highly educated folks into communities and to affect people that they've had no contact with their entire life. And then all of a sudden the expectation is that somehow they're going to help them out of a hole that they've never been down. Are you keeping up with me? Are you? Because this is this is serious. It happens all the time. But it usually happens in the metro area. They're not going to bring me from Minneapolis, St. Paul, to go to Apple Valley or to Savage or to Duluth to fix their problems. But yet they bring Apple Valley and Duluth and Savage to the cities to fix our problems. And I don't get that. I don't get that. The problem solvers are right in the room, right? So that's one of the points I want to make about the Ethos program and why it's so powerful, because what it does is it not only puts the people, but it puts funding behind it, and it gives you a real opportunity to be effective in the criminal justice system, which right now isn't that just. But it pulls away the mystique, it gets the community involved, everyone feels like they're heard, and then the crime usually doesn't happen again because we end up finding out that a lot of times it was done out of some type of necessity. And then once we could address that underlying need, they can go about their lives and usually live a productive life. But without that community engagement, we never get there. If we just lock them up, if we just sentence them with a mandatory minimum, well, once they do their time, the expectation is that, oh, they should be done. They should move on. But the work never even got started. So one of the things I will say that I really love is, like I said, the Ethos program. It's an amazing program. I've been honored to be a part of it, and I do hope that Minnesota explores other diversionary programs. I'm sorry, I went on a tangent there. My bad.
No, that's okay. And I'm just going to say it's hard for me to say what I think that Minnesota is doing right when, again, the crime rate has dropped and our prison rates have risen.
Oh, no.
So it does. I like to say that we're doing something right, and also, again, it's hard. Again, when it's been 12 years that we've been asking and lobbying to get our voter rights back. 12 years in Minnesota. That's supposed to be a progressive state. We're not moving forward with anything to actually start to make the changes. There's been talks about it. There's been these things. There's on a local level, I would say we have a much larger push. I also give props out to Ramsey County because I'm also involved in a lot of things to bring down their incarceration rates and to start to change some things. But that's one county out of 87. That's one county out of 87. And we're talking about the majority of our state is rural. And we can't get people to even talk there about restoring votes to people that are taxpayers, that are out in the community doing the work. So it's hard to say what we've been doing right when I'm coming from a side that's like, well, we're still in the same place.
I think we have an audience question response.
It won't exactly fit on a 3x5 card. Seems like you have an extra space at that table. I think it would have been very helpful to have a victim of violent crime on the panel and ask them if they thought we had too much incarceration in Minnesota. It appears that the victims of violent crime by Native Americans are usually other Native Americans. The victims of violent crime by African Americans are usually other African Americans. I think it would have been very helpful and balanced to have some people of color who had been victimized by violent felons and ask their opinion on how they think the system is working or not working.
Can I answer that? Because I am a victim of violent crimes. I've been a victim of violence my entire life. As I can say that most people that are incarcerated are victims. And I can also answer your question on that because I was a victim of a white man as a Native woman. Multiple white men as a Native woman. So when you're talking about victim and offender, which we don't like to use that language, or felon, because I committed a felony. Yes, I did. I also am a victim of a felony, multiple ones, right? So we have to stop othering people and understanding that the women that are in Shakopee right now, we have data that are 80% of them have reported sexual and violence against them. That's just reported. So there's not a separation between victim and offender when we come down to mass incarceration, because not only am I a victim of violence from other people in the community and men and other people that have done things to me, I'm also a victim of the state and the violence against myself as a state, because I talk about my trauma, the trauma that I've had my entire life from the community and that's happened in the community. But I also have the deepest trauma that I have is the trauma of incarceration, of being ripped from a community, being ripped from my family, being dehumanized. We talk just on that level, talking about having to be strip searched anytime that I had someone come to visit me. Anytime that I had to leave for a medical appointment, that's sexual assault also. Our brains are not that complex where they can say, nope, this is okay because it's for this reason. That's sexual assault, and that's why We Rise has pushed, and now to end strip searches in Shakopee, and at the first of the year, they're implementing an x-ray machine, so there will be no more strip searches because it is sexual violence. So again, I don't mean to go off, but there is no separation between victim and perpetrator when it comes to people that are incarcerated.
Can I also add here that it's a lot easier for a prosecutor to get a conviction in a case that involves a police officer witness, where, for example, a drug case or a gun case. Much harder to get it in a case involving interpersonal violence. And in fact, these cases frequently don't get arrested, don't get prosecuted, and get dismissed or get plea bargained at a much lower rate because of the concerns among the prosecutors that they won't be able to sustain that conviction because they have no eyewitnesses other than the two individuals involved, for example. And I'm not criticizing them for making those decisions, but I think that we need to separate out cases where prosecutors are making very conscious choices about the quality of the evidence that they're dealing with versus cases where they're run-of-the-mill routine cases, straightforward. You were driving with a suspended license. There's, the hundreds of thousands of misdemeanors that get prosecuted every year. Drug cases where you've got several police officer witnesses to sustain that case or to sustain a gun case. And so those are cases that the prosecutors will prosecute much more forcefully. And they're the ones that we then end up seeing a lot of the long sentences that make up our incarcerated population. So when you say having a victim here, to respond to the issue of mass incarceration, we're talking almost like two different things because in many cases, victims may well say, I didn't feel heard by the prosecutor. I didn't feel that I was given a respectful viewing. I didn't feel that people took the time to investigate my case. We certainly hear that a lot in rape cases. And so we may need to have to think about how we give succor to victims of violence and support them and prosecute their cases. And at the same time, we can have this conversation about the fact that we have people serving too many sentences and for too long, and that we also have set up a kind of a cycle where people will get violated for low-level things and back in prison. And so that's what contributes to our numbers in prison.
You just made a great convincing argument for more prosecution and more incarceration.
I think there's a different. What I'm trying to say to you is that.
Voice to the victims and prosecute more and incarcerate more.
Well, I think that that's not.
Did I not hear your message?
That's not what I said. I think that we need to talk about prosecutorial priorities, and I think that if we had those priorities, we may end up where the crimes that you are talking about, that you want to see prosecuted more forcefully, could be done while at the same time we're not filling our prisons with people on low-level, nonviolent cases and processing so many thousands, hundreds of thousands through our system every year on misdemeanors.
The Me Too movement is about listening to the victim. Harvey Weinstein is going to trial next week. He'll be going away for many, many decades, and people are cheering.
Well, he's innocent until proven guilty, actually.
The prosecutor is just a pass-through entity. The victim has the voice, which should translate into effectuating the prosecution of the crimes and incarcerating the defendant. So I guess I'm hearing two different messages: back off on crime or prosecute crime and listen to the victim.
I think you're assuming that the victim wants someone to be locked up, that's going to give them their closure, because that's not true either. In all cases, that's generalizing. Usually, what they want is for the person to not commit continue to commit the crimes, right? To not continue to commit, even when it comes to sexual assault, or you're talking about sexual molestation. Do you have the victim's been asked if they want their perpetrator to be locked up? I bet they haven't. I also went through, again, I can speak for my own self, have been through the system when I was violently raped. And I was never asked what I wanted. Never by the prosecutor. There was no pass-through of the prosecution, none at all. I wasn't even barely brought into any of it until I was asked to come to the sentencing. So, and that's you're assuming that every victim wants someone to be continuously punished. No, they want it to stop. They want them to be able to stop and to continue on their healing journey, to be able to move forward. And assuming that someone's locked in a cell and their families are also going through things and there's no rehabilitation, how is that giving any sort of justice to that victim?
The 40 victims of Bill Cosby didn't want to set him on a healing journey. They wanted him to go to jail for the rest of his life.
Did you ask them yourself?
They've been very vocal about what they want.
And you're talking about a very high-profile case. You're not talking about a child that's been...
It's one rich and powerful man who's gone to jail for the rest of his life.
And that's your opinion, and you can keep that opinion, but we're going to continue to keep working on healing and building our community towards the new world where we don't have to separate victims and perpetrators.
Very good.
I'm sure the perpetrators will be happy to hear that they will be separated from the victims.
All right. Do we have any more comments just on general? Okay. I guess for a final question here, do you have comments as to, at least with your experience, on which has a larger effect on increasing the prison population here in Minnesota? Do you think it's more of a prosecutor attitudes kind of effect, such as the tough on crime talk, or do you think it's motives of the state legislation?
I think that you're going to talk about both sides here, right? Because we can look at some of the legislation that we're looking at bringing to change, defining what is a crime of violence. In Minnesota right now, even if I have a dirty bag of heroin with just residue on it, that's considered a crime of violence in Minnesota. So that's part of it, right? Also, when we're looking at the laws of registry laws, right? That's also on a legislation level, and we also think that that is completely unconstitutional and not helping at all with protecting communities or bringing the mass incarceration rates down. I think that a lot of, again, when you're talking about rural communities, when you have a lot of county attorneys that don't have to answer to community because no one's running against them, for one thing, right? If you've been sitting in that seat for 30 years and no one talked about putting any pressure on you, or even the community's understanding that they have a voice. Well, you don't have a voice if no one else is running against that county attorney, and they kind of get to run the show.
I can jump in to say that the ACLU has gotten involved in dealing with some of the issues around prosecutor races in the last few years, largely with an understanding that, number one, most people don't even recognize that we, the people, elect our prosecutors, and that you should have a voice and you should care about what type of prosecutors they intend to be. I think for so many years, what we saw was simply a tough on crime mentality, and if you could show that you were locking the most people up, you were likely to get reelected. And that's changing. I think across the country, there's a much bigger interest in reform-minded folks in these positions actually coming in and trying to do what's truly best for public safety and the community, and that's not just locking these folks up. So we've been really trying to elevate those issues and make sure that everyone knows when they go to the ballot box that you have choices to make and that we can hold our prosecutors accountable. I think that's an important thing that we have to remember even when we are not in an election year. So part of me says, yeah, prosecutors have a whole lot of discretion, and they could decide when to prosecute an arrest, what charges to bring, what plea deals to make, offer and accept. But they can also divert people to treatment programs. They can decide not to seek enhancements to keep those sentences lower. Now, on the other hand, I'm also very disappointed in the attitudes that I've seen, and I think alluded to already at the state legislature, where we have a very difficult time breaking through with any type of reforms. And when you have the power to really decriminalize things instead of adding every year to the huge list of crimes we have in Minnesota, that could be very powerful. They can also fund alternatives to incarceration, including mental health and substance use treatments that are so very needed. So, who's more to blame? I think it's kind of a toss-up, ultimately, in my opinion.
Speaking of the reform-minded prosecutors, we've seen actually several defense attorneys become prosecutors across the country, run for election and become prosecutors. And then they start instituting decriminalization policies of not arresting for particular crimes that are on the books, and seeking diversionary programs, and also a bigger interest in restorative justice. So back to the issue of our, especially our victims of violence, sometimes, and I'm not saying that it's always the case, a restorative justice process can actually be very meaningful for them and can facilitate non-incarceration and keeping families together. And so, of course, this is going to take resources and effort and time and commitment, and it will take prosecutorial commitment, but there are alternatives to the concept of just putting people away and locking them up. And I also just want to say something about the quality of our incarceration in this country. I've visited, in this state, I visited many of the prisons, and I've walked through many of them with my students, and they're extremely depressing places, many of them. There's some great programs. There's a wonderful one. Willow River is a great program where people go for a 6-month kind of boot camp experience, and they actually get several years of their prison sentence cut off if they do that program, and it's in a beautiful area up north. But then there are the prisons that are these old-fashioned old prisons with cells and very few education programs, very little access to exercise, and then a huge cost to put on the inmates to connect with their families, several dollars to pay for a phone call or to pay for a video call. Particularly disturbing is in our jails that we don't have contact visits anymore. Everything's done through video. I don't know how these families maintain their relationships with their young children when the children are literally talking to them on video screens, and those video calls cost $8. A telephone call costs $7. The huge cost to get anything from the commissary and the prison. So we really should start rethinking the kinds of prisons we have. And here in Minnesota, which is a very progressive state, we could be coming up with prisons similar to the ones they have in Norway and Denmark.
That's very good. I think it's really about awareness. I've been a victimizer, I've been a victim, and when you're mad, you want retribution. But a lot of folks that have been victimized say they want to be heard. That's what's missing from the criminal justice system, the victim being heard, really. What is it, 90-some%, like 95% of people that are incarcerated are going to return to the communities, most times communities they came from. So when I say it's a matter of raising awareness, it's a matter of raising awareness in everybody, not just the prosecutors or our legislators. It's everybody, because let's just face it, certain folks are going to feel how they feel, and we're not going to change their minds. This is just how I feel. This is how I operate. This is how I act. These are the people I hang around. This is how I view things, and this is just how it's going to be. So what we're going to have to do is we're going to have to educate the folks that are coming up. That's why I appreciate these conversations, because we can educate ourselves out of ignorance. Like we really can, because we're living in real ignorant times right now, and we're like on this crash course towards like financial ruin, and we all know it. And some of us care, and some of us really don't. And that's the sad part. And that's why I think there needs to be a total level of just raising folks' understanding what's happening here. We are totally invested in this together. There is no us versus them. There's no such thing anymore. No matter how far you're out and how far you think you're removed, you're not. So I think I'll say all across the board, we need to learn a little more about this, get a little more vested in it, because it's going to take all of us to change it.
All right, sorry, we're actually out of time. So thank you all for coming today, and please join me again in thanking our wonderful presenters for coming today.
Thanks for coming back after lunch. I know you didn't have very long to go anywhere. I'm Kelly Mitchell. I'm Executive Director of the Robina Institute of Criminal Law and Criminal Justice, and I have the distinct pleasure of introducing our next panel, which will talk a little bit about risk and a little bit about parole release. Our first speaker is going to be Jessica England, and she is an Associate Professor of Law at the Maurer School of Law at Indiana University, Bloomington. She, prior to joining the law school, she served as counsel in the Justice Program at the Brennan Center for Justice at New York University School of Law. She clerked for the Honorable Damon J. Keith of the Sixth Circuit Court of Appeals, and she's also been a litigation associate at Simpson, Thatcher, and Bartlett in New York City. She's an expert in criminal law, evidence, and federal sentencing law. Going directly after her will be Professor Kevin Reitz, our own Professor Kevin Reitz. He's the James Annenberg Levy Land Grant Professor of Criminal Procedure here at the University of Minnesota. He most recently has served as a reporter for the American Law Institute's Model Penal Code revision to the sentencing section, a huge undertaking, a great project. And he's also served as our co-director of the Robina Institute of Criminal Law and Criminal Justice, and that's the area where I've gotten to work with him the most. He's working with the Institute on projects relating to prison release discretion. He's published extensively on sentencing, law, policy, and procedure, and on criminal justice policy in the US and other countries. So they're each gonna speak for about 20 minutes each. If you have questions, please go ahead and fill out those cards and send them to the sides, and we'll take questions after they've both had a chance to present. Please welcome Professor Eglin.
Hi, thank you so much for the opportunity to be here and for sticking through in the after lunch lull. So I am excited for everyone that is here. All right, so in Professor Zimring's forthcoming book, he lets us in on a little secret that many criminal justice reformers are aware of, which is that reducing mass incarceration or efforts to reduce mass incarceration are up against two hurdles. One hurdle is to stop the increase in incarceration, but the other hurdle is to stop the threat of stabilization, right? Saying that we've done enough, the prisons are full, we've figured out enough ways to stop the increase that we don't need to change the criminal justice apparatus any longer. And he's writing against that when he says, and the focus of my contribution, I guess, he's writing against that threat of stabilization when he suggests two different sentencing reform paths forward. And the first, the one I'm going to be talking about, is laid out in chapter 6, where he talks about, which I would call the categorical alternatives to prison sentences. And that can be simplified into a more simplified way of saying it is he looks to drugs and jails as promising routes for reform. In this talk, I'm going to be examining what that proposal, or potentially two separate proposals, depending on how you read the chapter, what that proposal suggests, and highlighting the tension it has, or that it presents, with another very popular sentencing reform proliferating across the country, which is the introduction of actuarial risk assessment tools. And actuarial risk assessment tools are these tools or instruments that are designed to assess the likelihood of an individual defendant recidivating, engaging in particular criminal behavior again in the future, based on statistical analyses of data collected about past offenders and their behavior in and out of the criminal justice system. So that reform is very controversial, and I think there's an interesting tension that arises between the categorical reforms that Professor Zimring suggests in Chapter 6 and the tensions or the debates that have arisen around this separate sentencing reform that he does not explicitly discuss. And if I have enough time, hopefully, I will conclude by thinking a little bit about what he identifies as potentially the reform goal, which is to move away from mass incarceration and to be satisfied with mass incarceration light. All right, so Zimring's proposes a provocative decarceral agenda, sentencing reform agenda for the next 25 years. He suggests that we should remove, or we have the option, I guess, of removing categories of offenders from prison eligibility, or shifting responsibility for some of these categories of offenders or offenses from state to local criminal administrators' responsibility. So he suggests that states could remove categories of offenders from prison eligibility and possibly from criminal responsibility altogether. In particular, he focuses on the promise of diverting drug-addicted offenders. As he explains, much of the increase in the prison population across the country can be attributed to the war on drugs in the 1980s, even though we see a massive increase in the length of sentences for all offenders. There is sound reason to focus on drug offenders in particular, because that penal policy increases or has affected, I think he said, produces twice as many prison convicts and affects twice as many families and individuals who are connected to those who cycle through for prison, for drug offenses in particular. So he suggests that there is momentum to shift the way that we respond to drug-addicted offenders by diverting them from prison to potentially treatment programs writ large, or possibly, although he doesn't necessarily say it explicitly, possibly removing responsibility, criminal responsibility for these individuals altogether. So the momentum, he suggests, draws in large part from a social transformation in the character of the drug offender. So the current opioid crisis contains or pertains to drug offenders that are not the, quote, usual suspects, as he suggests. The characteristics or the profile of these individuals are individuals who are older in age, come from middle America, and most likely were addicted to painkillers and shifted from painkillers to opioids, to prohibited opioids. And he suggests that if there is a flaw he goes through, I also am not an empiricist. I was really happy to see Bob go first. So you're only going to get so much statistics out of me. But he suggests that if we look at the victims, right, those that overdose on opioids, in comparison to the prison populations, that we will see that the individuals who are victims of the opioid crisis are not being captured in the criminal apparatus. And so he suggests that this might be a moment to catalyze for broader reform on drug offenders in particular, where the failure, he suggests, of the opioid crisis for criminal administrators is their inadequacy or their inability to admit their inadequacy to handle this public health crisis. So people are addicted, criminal enforcement can't really handle that problem. That's that's a large part of what the opioid crisis brings to bear on criminal enforcement more broadly. And if that is the case, then potentially we can expand that insight out from just the opioid crisis to the original war on drugs and the focus on crack offenders in particular, to say if we're not good at dealing with opioid offenders or opioid users, then maybe we're not good. The criminal justice system is not good at dealing with drug-addicted offenders more broadly. And if we can use that, if we can use that insight to shape our reforms, we could carve out a large category, drug-addicted offenders, or particularly individuals who have been convicted or of particular drug offenses, as individuals who are no longer eligible for prison sentences and instead would be diverted potentially to drug treatment or someplace else. So in this sense, his call for reform aligns with a broader trend in criminal justice reforms in the states more broadly. So there has been, since 1990, an increasing popularity in what are often referred to as drug treatment programs or drug courts that divert low-level offenders who have been convicted of low-level offenses, usually drug offenses, to treatment programs in lieu of longer terms of incarceration. Zimring's proposal goes further, however, because he suggests that rather than allowing individual local prosecutors, judges, to individually select which individuals would be diverted into these alternative treatment programs, thank you, the category writ large should be prohibited or limited from that discretionary decision, instead automatically sort of pushed towards non-prison sentences. His second proposal, which we heard John Pfaff talking about a bit earlier this morning, talks about realignment, realigning criminal financial incentives to reduce reliance on first prisons and hopefully, in the long run, also incarceration by diverting individuals to jails. Jails are, as he suggests, a solution to the correctional free lunch problem, wherein states pay for prison, but the individuals who make the decisions about who gets prison sentences do not also incur those costs, right? So prisons are cheapest for local actors, and jails are not. So the hope is, as John explained, the hope is that by realigning these financial incentives, ultimately, the local actors have incentive to reduce reliance on incarceration. This also is drawing on, in particular, California reforms. California in 2011 implemented the Public Safety Realignment Act, which this legislation shifted responsibility to punish and supervise the non-serious, non-violent, non-sex offenders with no serious history of, or no history of serious convictions from state to county level. So each of the state's 58 counties in California decide how to deal with these individuals, and what we see and what his chapter lays out is that while there was a sort of predictable increase in reliance on jails, initially after public safety realignment was implemented in California, we then subsequently see a joint reduction, a reduction in the prison population in California, but also a significant reduction in the jail population that is now sustaining at a much lower level than the peak 2007 rates of incarceration. So where is the tension? So as I said, a very popular reform right now is the introduction of actuarial risk assessment tools to shape judicial discretion and various other actors' discretion in the criminal apparatus. And the idea is these tools will create categories of people. They create categories of low, medium, and high-risk individuals based on this statistical analysis of past offenders' behavior. So somebody who shares the characteristics of individuals who recidivated in the past, what might be high risk, but somebody who does not share those characteristics are low risk. This is a deeply controversial criminal justice reform. Many of you probably have seen something about it in the news. ProPublica released a report in, I believe it was 2015, talking about or asking the question whether these tools are biased. Are they racially biased? And then you have back and forth between empiricists and criminal justice policymakers saying, is this a good policy decision to implement risk assessment tools, which may potentially exacerbate racial disparities, in part because the tools rely on past data, bad data, data that was collected in the era of mass incarceration. So if we know that criminal justice actors have disproportionately targeted the poor and racially marginalized communities, that's what the data is going to base their predictions on. So these are, as Zimring might say, the usual suspects. That's what the risk assessment tools are designed basically to identify. This creates a tension, or I'd suggest two tensions. His reforms call for categorical reform, right? To say categories of offenders, categories of offenses should be treated differently and should be diverted from prison sanctions. But the first tension is, what does categorical mean? Because Zimring refers to categorical to suggest broad swaths of offenders, individuals who have been convicted of similar crimes, individuals who have been convicted of similar crimes to be diverted, to be no longer automatically prison eligible. And again, he draws on public safety realignment, but he more expressly draws on Proposition 47. Proposition 47 passed in California in 2014, and it reclassified several low-level nonviolent offenses that used to be what Californians call wobblers, meaning offenses that prosecutors could choose to treat as misdemeanors or felonies depending on their own discretion, to carte blanche misdemeanors, meaning that they were no longer prison eligible. And when combined with with public safety realignment, it created a broad population of individuals who are no longer prison eligible. All right, so this idea of categorical is different from the categories that are created by actuarial risk assessment tools. Actuarial risk assessment tools rely on basically administratively created categories. So somebody that is high risk, and the idea is that the tools will identify individual defendants who, based on their similarities to others, are not likely to engage in future criminal behavior. So on the one hand, using an actuarial risk assessment tool could potentially be far more progressive in a decarceration proposal, because it cuts across different categories of offenders. Risk assessment tools have actually been quite popular, in particular, in reducing reliance on incarceration for individuals like sex offenders, who are the least sympathetic amongst the criminal population. Zimring, on the other hand, does not really focus on the least sympathetic. Instead, he says, let's double down on those least sympathetic, or the most sympathetic, individuals in the prison population, drug offenders, and expand out to say more drug offenders cannot be directed towards prison. So, while it seems that these are two different categories, but just two different categories, either is a possible way to proceed, I want to suggest that Zimring's use of categorical is actually undermined by the use of actuarial risk assessments, because, as he suggests in his chapter, one of the problems that the categorical imperative, as he suggests, is trying to avoid is the issue of cherry picking. The idea that we can pick one or two individuals who really shouldn't be in a system that is otherwise operating quite functionally. And as he suggests in his, thank you, as he suggests in his book, the benefit of a categorical approach in large part has to do with the clear message that it might send, which is that business as usual, right, doesn't work, that something is wrong with the the criminal apparatus, and that sentencing can send that message through the reform. Actuarial risk assessment tools, on the other hand, don't send that message, right? They say business as usual would be fine if we could just do what we do a little bit better, more accurately, more consistently. The other tension I want to identify it has to do with responding to changing social practices. So actuarial risk assessment tools at their core are a type of profiling. The idea is that we can profile individuals who are entering the prison systems and identify those few who should not be there. In his book, in Bernard Harcourt's 2007 book, Against Prediction, he questions the efficacy of profiling writ large in the criminal justice system. And the problem is that there are some people who are visible, thank you, there are some people who are visible in the data that is used in the criminal apparatus, or that's collected in the criminal apparatus, and others that might not be. And so the concern is that individuals who are visible are going to be disproportionately targeted when we increase our reliance on predictive tools, while individuals who are not often swept up in the carceral state might not be, in which point they have a higher or an easier opportunity to engage in crime. Well, this is exactly what Zimring identifies when he talks about the concern of the opioid crisis. So he suggests that part of the problem with the opioid crisis, is that the individuals who are swept up in the opioid crisis aren't the usual suspects. But this is exactly what Bernard Harcourt was talking about when he suggested the problem of a ratchet effect. That there's the opportunity for crime to flourish in areas that we are not looking because that area is not where we traditionally would look. And instead of using that as a basis to increase incarceration, right, to say, let's move the criminal apparatus to capture more individuals by bringing it to bear on the opioid crisis, let's use this as a message or as a moment to reflect on whether the criminal apparatus is the best way to respond to what is a social crisis. So I already went over my time, but I'm going to take this one last minute just to raise, so what we see is this tension, this idea that actuarial risk assessment tools might be a good intervention. What Zimring's categorical imperative suggests is that it is one way to proceed on criminal justice reform and sentencing reform in particular, but it is by no means a necessary precursor to any kind of further decarceration. I want to suggest that it can also be in tension with reducing incarceration levels further and instead encouraging sort of the status quo. And that, I know I really don't have time, so I just want to say that would be problematic if our larger agenda is in fact decarceration. And I hope in question and answer to talk a little bit about what are the contours of a decarceration aim in line with Professor Zimring's discussion in the book. Thank you.
Okay, my talk will overlap a little bit with Jessica's toward the end, but the main message I want to make is that any serious attempt to think about mass imprisonment as a national phenomenon that we need to encounter probably in different ways in different states needs to pay serious attention to what I call prison release discretion, which is once you've been sentenced by a judge and put in prison, who actually decides when you get out? Who actually decides how long the sentence is going to be, what the time served on that particular sentence is going to be? And in 2/3 of the states today, a big chunk of the American states, the big player in determining time served is the parole board in those states, together with departments of corrections that administer good time and earned time credits. Sometimes those credits are a big deal too, depending on the state. But the primary subject of this talk, or the primary protagonist in the story, is going to be the American Parole Board, at least in 2/3 of the American states. And I guess what the one message I'd like to get through is that a decarceration agenda, to be complete, to be comprehensive, to really not be overlooking any important piece, needs to include a lot of attention and creativity on problems of prison release discretion. One of the things I very much like about Frank's manuscript is that he does pay attention to this issue. On the other hand, if you read most of the literature on mass incarceration, most of the discussions in the media, and even at the level of the National Academy of Sciences, you see very little attention given to prison release discretion as an element contributing to mass incarceration and possibly as a big part of the solution. Now, if I can find my slides. I don't know if I can. End slideshow. Oh, here we go. This looks good.
So, if you put it back in presenter mode.
Oh. Why can't I just start the slideshow?
Yeah. So you'll do this one, and then I'm going to click with this.
Okay. Oop, that's not mine.
Start it over. Sorry.
Sorry about that. I don't have that many pictures, but I think they're attention grabbing. So. Yeah, I've hardly ever been to a conference where there wasn't some PowerPoint glitch. You'd think in this era of technology, someone would have figured out just how to make PowerPoint work. Oh, that's not me either.
We're reviewing the whole day.
Okay.
Everyone needs a summary.
Great.
For our quick learners in the room.
For those who came in late.
Yeah.
Sorry.
Yeah. But some of these folks had a lot of slides. Okay, so that's me. Okay, and you see prison release reform, to me, is at least one critical element of any serious approach, audacious, kind of ambitious approach to mass incarceration in the U.S. And I want to give you an example just drawn from a couple states of how prison release discretion works, at least principally at the level of the parole board. Okay, so a fairly traditional state that might accord with a lot of people's preconceptions is Georgia. And what this diagram is a timeline from the day of admission all the way on the left to all the way on the right, the maximum term that a given prisoner could serve based on the sentence that they received in court. Okay, and most prisoners are going to serve, the time served is going to be somewhere in between admission and the maximum, maybe not going all the way to the maximum. Now, what this diagram is showing by the part of the timeline in black is that in Georgia, 33% of the maximum sentence must be served according to the judicial sentence in most cases before anyone has the opportunity to release that person. Okay, but at the 33% mark, parole release discretion comes into play. So the parole board, for the majority of prisoners in Georgia, could release you at your 33% mark, at your 50% mark, at your 70% mark, at your 100% mark. And I think it's useful to quantify how this system works in individual cases and then scale it up and think about how it works across the whole system of prison policy in Georgia. That the parole board in this diagram, I would say, has the discretion, the release discretion, to subtract as much as 2/3 or 67% of the time served that would be there if you served the full maximum. Okay, so that's one way of looking at it, and that suggests, oh, parole boards have a lot of power in the direction of leniency. Okay, but anytime we see this degree of discretion, we need to mentally flip it. Because a situation like this, or a setup like this, could be described as a parole board that has the power in any individual case to triple the minimum term of the sentence by extending it all the way to the maximum. So every time we look at a parole board with a lot of what appears to be power in the direction of early release, leniency, I think we also have to think about release denial discretion, which is increasingly what we see in parole boards. Rachel mentioned this this morning. But I think of parole boards often as release denial agencies rather than granting parole across the country in 2/3 of the state. Okay, so this is Georgia, and if we scale it up and think about the whole system, and this is most prisoners in Georgia, it's not all, but let's just think about the part that's under the jurisdiction of the parole board. If the parole board were to release most or all people at their first release eligibility, you would get one level of prison population resulting from that if that were the practice over time. On the other hand, if the parole board was more likely to hold people close to their maximum term, you would get a different prison population in the state of Georgia, at least for those prisoners within the jurisdiction of the parole releasing agency. So the parole board's power over that prison population has a ratio of 3-to-1, right? The parole board, if it lets people out early, maybe you have a prison population of 100 per 100,000, whereas if it's holding people more towards the maximum, it can go up to 300 per 100,000. That's the swing of possibility in a relatively ordinary paroling state. Okay, so this is Exhibit A for my case that we've really got to pay a lot of attention to how that 2/3 of the line is working in states that still have a parole board making decisions of that importance. Now, I just want to jump ahead. Yes, this is Iowa. The timeline of a prison sentence in Iowa has no black component. It's all gray. Because in Iowa and 5 other states, the parole board has the power to release prisoners on the day they're admitted. There is no minimum prison term in Iowa and 5 other states, or the parole board has the power to hold people for their full maximum term. Okay, so within the limit of what holding everyone for their maximum term would create in the state of Iowa, the parole board has 100% of the authority over time served and has the power, if you scale it up as a system as a whole, just has a breathtaking power to affect prison population size in their state. Okay, now one thing I want to emphasize about these charts is that they are depicting the law, the legal structure that exists in these states. The Robina Institute took 4 years and devoted a lot of resources into looking at all 34 paroling states in the country. We have a separate report for each state on the law governing parole release, parole revocations, parole supervision. And we found a huge diversity of approach, just as you see in these first 2 slides. But this is how it is on paper, right? There's a lot that we don't know about how much of this discretion is the parole board actually using? Maybe everyone in Iowa gets out of the 33% mark, even though potentially the parole board could be handling it very differently. Maybe everyone in Georgia is getting out of the 33% mark as well. But one thing I would point out about both of these systems and just about every paroling system in the United States, however that system is working at a particular moment in time, it can change with very little friction. It's a highly lubricated system in the sense that a parole board in Iowa that is letting most people out at the 20% mark could decide next week to start holding everyone for 80, 90% of their sentence. That would not require any legislative change. It would require no change in regulations. It would require no change in judicial behavior. It would require no change in prosecutors. It's just this little parole board, and we have seen this happen in a number of states in the country, especially in after 1990s and since then, when a single horrific crime is committed in the state by someone who's been released from prison. And suddenly release rates go from whatever the number was to zero overnight. Okay, so, and that can happen with no friction. There's no lawmaker, there's no change in the formal law. There's simply a change in the type of pressure that the parole board is feeling and what it decides to do. Now, just as importantly as those sort of immediate changes where release practices turn on a dime, the actual release practice of a parole board in a system like this or in a system like this can change dramatically but slowly over time. So you could have a parole board in the 1970s administering a law like this in a way that produces what we might think is a reasonable prison population. And yet by the 1990s, it has changed its behavior with no change in law or the behavior of anyone else in the system, so that the prison population under their jurisdiction has tripled. So that's what I mean by a very frictionless and, to my mind, a dangerous system to set up in terms of determining time served. Now, if I were acting as a consultant to the state of Iowa, and they want to know a few things. What should we do about our prison population today? What should we do about the future? Let's say there's another political crisis, there's pressure in the future not to release people and therefore increase the prison population. What should we do about our problem today and a problem in the future if we have that political pressure? Again, and I would tell them, you have got to think of some way to bring this under control. Because this kind of a system, your prison policy just swings in the breeze, right? And the parole board has, like I say, just breathtaking power over time served, okay? And it's not just Iowa and the 5 other states I mentioned that have this kind. We worked in Colorado for a couple years, and we found for minor sex offenses, the typical sentence handed out in Colorado was 1 year to life, or 2 years to life. And we saw a number of hearings involving sentences like this. The parole board, in making its decisions within that framework, again, is in control of the prison population for that segment of the Colorado prisons. So if I were a consultant, I would tell state, you've got to figure out a way to bring this under control, partly because if you do, if you make the prison release system work the way you want, it could bring about dramatic decreases in current prison populations. We thought we saw that in Colorado, that if you simply released the lowest risk category of people who came to the parole board, you can count, and their prison population would have fallen quite dramatically. So getting some degree of control over this is important as part of the cure of mass incarceration, and also I would suggest as an equally important benefit, which is better control of systems like this would better insulate them from runaway prison growth in the future if we enter another era of tough on crime or moral panic about one crime or another. Now, I have other slides I can show you, but I don't think I will. Instead, I'll just mention, and this is where I dovetail with Jessica's discussion. I think we do have some tools, or at least some ideas available to us, that could take more control of the paroling process in states that still have systems like this. And one idea that seems especially promising to me is to rely to a much greater extent on risk assessment instruments and their ability to identify prisoners who are at an extremely low risk of future violent offending, especially serious violent offending. The Pennsylvania Sentencing Commission has recently done a study on prisoners and the people who are coming through the system. And one thing they found, this to me is an impressive number, that if you use this, if you have a risk assessment instrument, it's the best one you can come up with. If you try to use it to tell you who the most dangerous people are, way up at the top end of the violent recidivism curve, it's not very accurate, right? In Pennsylvania, I think in that category, the commission thought they were getting 11 out of 100 correct in terms of trying to find the most violent. But in that larger category, where the instrument was telling them who is at trivial risk of a serious violent crime in the future, or indeed of any violent crime in the future, their projections were at 98% accuracy. Okay, so risk assessment tools are rightly controversial. They're scary in a lot of their applications, but I believe they can be used to one good effect immediately and in the future, and that would be to help us identify a meaningful category of people who have no business being in prison. Right? If they're there, they ought to be released, perhaps automatically. Maybe we should be identifying a lot of these people before they're even admitted to prison. Right? So we have this, actuarial power that really can be used in the direction of lenity. And to me, this helps with both of the problems I've identified. It will take a chunk out of the current mass incarceration a problem in a large number of American states. And once you have this substantive policy enforced that very low risk of violent offending people are not supposed to be in prison, once that substantive policy is in place and it's evidence-based and it has a track record, that is going to help those states resist future unwanted, unplanned explosions in their prison populations as well. The subject of importance that I think nationally we have to pay more attention to is prison release discretion. Who gets to decide how much time is actually served on a prison on a prison sentence? That power ultimately contributes a lot to prison population size at any given moment. And the suggestion of the kind that I'm making, and many others maybe we could think up, would also help insulate some of these systems so they're less vulnerable, just less free-floating and less vulnerable to being pushed to the red line side of the needle when there's a crisis or when there's political pressure to do so. So I'll stop there, and I think I'm on time.
All right, thanks to both of you. We have a couple of questions, but before we get there, Professor Eaglin, I think there was maybe a word or two more about decarceration that you wanted to say. So I'd like to give you a minute to go ahead and tell us what you're thinking there.
So I think that what excites me about Zimring's proposal, is that it begs this bigger question of what we want the criminal justice system to do. That the criminal apparatus isn't supposed to be the only, I think it was Rachel said it in the morning, like this is a huge government resource, right? And it's not the only one. It's not the only way that we respond to different crises. And when you start to say there are categories of offensives, categories of offenders that aren't supposed to be here, that this isn't the way we should be dealing with it, that doesn't mean we're washing our hands of the underlying problem, particularly in the context of drug offenders. But it is raising a bigger question of what it is we want the criminal justice system to do that goes beyond just being efficient and saving money, but also to this deeper question of what do we think good governance is for a healthy democracy. And so I think that part of the benefit of that categorical imperative is that it drives at those deeper structural questions that can often be written out of particularly sentencing reforms in the hopes of sort of avoiding the hearts and minds critiques.
All right, great. So one of the first questions we have, you both mentioned risk assessment, but I think this might be directed more at you, Professor Eaglin. What role, if any, can risk assessment play in restorative justice programs?
So thank you. It's an interesting reality that actuarial risk assessment tools are used all over the criminal justice system right now in ways that we don't necessarily realize, including restorative justice programs. I mean, so the way that people often are diverted from their prison-directed sentences is a prosecutor who will say, I don't want to send this, or I'm willing to send this person someplace else. And actuarial risk assessment tools provide some sort of basis to say this person is a good candidate for diversion. So that sounds great, but in doing that, we often will leave individuals who might also be able to succeed in rehabilitative programs, and in fact, might be people who would benefit the most from restorative justice or rehabilitation because of the tool identified them as someone that looks like other people in the criminal justice system. So it can cut both ways, and I think that. Honestly, I am very much in agreement with Kevin. I think that if we're going to use risk assessment tools, the place to do it probably is in the parole context. That this person's already serving a sentence and it can be used in a way that's effective towards reducing that level of incarceration. But even when you start talking about some of these diversionary options, you're carving out large swaths of people who won't qualify because they look like people who are already in the criminal justice system, and that's disproportionately going to disadvantage the poor and people of color who might also benefit from the privilege of restorative justice initiatives.
Do you have anything to add or no?
No.
Okay, so Professor Wright, over to you on your parole issue. One of the questions from the audience was basically, how often do parole boards like Iowa and Georgia actually grant parole as early in the sentence as they can? And does there seem to be a pattern in that? So what have you come up with so far?
Okay, well, what we found on that type of question is a near total absence of data. It's hard to figure out at any given slice of time how the parole board is using its discretion, which you would want to know. But what you'd really want to know is what were they doing 2 years ago, 5 years ago, 10 years ago? What might they be doing 2 years from now, 5 years from now, 10 years from now? So we really need longitudinal data. There is a potential source for that kind of work it's called the National Corrections Reporting Program. It's just a huge body of very messy data that the U.S. Justice Department has been compiling since the 1980s. One of the strategies of the Robina Institute is to try to get funding to get into that and open it up and actually watch states over time in terms of how they're treating individuals, where there's a lot of release discretion. Are they getting out early or late? What's happening with good time credits? Are people getting denied 16 times in a row? Can we figure out why? I think that we urgently need to know the answer to questions like this. But at the moment, even if you go to the states themselves, they don't know and have no way to tell you. Okay, so part of my pitch is just to convince people that this is important enough to look into and to try to figure out, both because we want to understand how we got to mass incarceration and the important drivers of that, and we want to understand the potential, particularly of paroling systems, to help us reduce, to get out from under the problem.
Okay, so I think we have the challenge question. All right, the question is, what about the wealthy who pay for their kids to get into good colleges? Aren't they low-level offenders? Isn't jail time their strongest deterrent? Is time meaningless to this population? Anyone want to tackle that one?
Okay, well, I think someone said, I spent years working on the model penal code, sentencing provisions. And what the model penal code says is, no, don't send them to prison. But also, the property offenders, the drug-only offenders who are currently going to prison, they have no business going to prison either. That prison is for two things. It's for the people that we have some reason to think are dangerous of violent recidivism. And in some cases, it's just pure retribution. If the crime is so serious that only a prison sentence will do, then send someone to prison. If you look at the research, it's hard to believe in deterrence, right? It's, the model penal code would say, no, don't send them to prison. But then there are a lot of, categorically, as Frank says in his categorical arguments, there are lots and lots of people who are currently prison-bound today who should also just not be on the table for a prison sentence.
Yeah, I would just echo that and say, I think part of the challenge when faced with those kinds of examples is this sort of impulse to level up, right? To say that the problem is that these people who are more privileged should be getting the same kinds of punishment as individuals who are less privileged and find themselves in the criminal justice system more frequently. And it's really important to fight against that and say, should that person, should a wealthy individual who paid to get their child into college go to prison for or be incarcerated for more than 2 days? Or can we say, well, if that's the kind of person that doesn't get incarcerated for more than 2 days, who else should not be incarcerated for more than 2 days? And I think that that's a shift in the frame of what it is that what we're really aiming towards. And I think in Professor Zimring's book, there's this point when he talks about that in the context of the opioid crisis, right? The solution could be to ratchet up the punishment of individuals who engage in criminal behavior to obtain opioids, or the solution could be to use the fact that we are responding to the opioid crisis as a public health crisis as an opportunity to reflect on what other types of public health crises we've responded to with our carceral arm, and potentially say that that's not appropriate.
I think I just realized I'm not sure what time we end on. 1:30. Okay. All right. So I think that I'm out of questions up here, and it looks like we have time for probably 2 questions from the audience. So is there anyone out there who has a question that they would like to ask? Right over here. Thanks.
Assuming that people of color have a higher likelihood of being stopped and arrested, does actuarial analysis have a way of filtering out and predicting likelihood of recidivism?
So there are sort of short-term solutions and then there are longer-term solutions. So one of the concerns with actuarial risk assessment tools, and not the kind that Kevin's talking about, but the kind that are often used at sentencing, predict likelihood of rearrest in like 3 years or something like that. But we know that arrest data is perhaps the most sort of shaky data that we could use, and that there's a lot of evidence that there's problematic drug enforcement as a good example that is reflected in arrest data. So one solution is to move to convictions, but of course, convictions for what? How do we define what violence is? How do the tools define what violence is? Like those are very granular questions, but the way that we resolve those kinds of questions, what it is exactly we're predicting, is going to have a big impact on exactly how racially disparate the effect of the tools might be. And so that's one place to start. But the truth is that, and it's an ugly truth, is that when you start talking about race in the criminal justice system, race and crime, that you are also talking about a higher victimization. I think it was well stated in the lunch panel where what is the woman's name? Tanya was saying, that victims of crime are often minorities, people of color, just as much as the perpetrators of crime might be. And there are reasons for that, structural reasons for that. But the improvement, the sort of tinkering with the tools are only going to do so much to avoid sort of the bigger questions about where we want to put our criminal justice resources in a way that is not going to increase or stabilize problematic racial disparities.
Can I just add to that? Okay. The other sort of element of importance here is, as Al Bloomstein said today, if we can think of anything that substantially drives incarceration rates down, because the current status quo is so racially skewed, minority groups, people of color in the system, stand to reap benefits disproportionate to those benefits that white people in the system. For example, the average black neighborhood will see more people returning from prison than the average white, even poor white neighborhood, because the incarceration system is skewed. Anything that brings it down by 20% or 25% in terms of the black community there's going to be a strong tendency to disproportionately benefit the people who have disproportionately suffered.
All right, and so with that, I think we'll do the one last question there.
Excuse me, what role, if any, should risk assessment play in the restorative justice program? Or should it at all? Because you're talking about perhaps a community program which doesn't put people in prison, but there's an agreement, the state would have an agreement to resolve some issues, and that would seem to be the sticking point in the middle.
Yeah, I don't necessarily think that you need a risk assessment tool to put people into a restorative justice program. But I think that's one way. I understand, to me, there's just multiple ways to get someone into a restorative justice program. I think earlier we were talking about how some states or some jurisdictions started out with low-level nonviolent offenders, and now most of the restorative justice program is directed towards violent or serious offenders. And so if you say that the only way we're going to let you in is through an actuarial risk assessment tool, you sort of preclude the possibility that there are individuals who might be sort of quote-unquote high-risk individuals that might be the most receptive to it. And so what Zimring's proposal suggests is that a categorical approach might be another way to sort of fuse into even restorative justice initiatives.
All right, so I think with that, we've reached the end of our time. Please join me in thanking Professor Eaglin and Professor Wright.
Hey, good afternoon, everyone. My name is Perry Moriarty, and I'm a law professor here. And it is my privilege to introduce the panelists for our next session. Professor Richard Fraze is the Benjamin N. Berger Professor of Criminal Law and co-director of the Robina Institute of Criminal Law and Criminal Justice. He is also the founder and co-director of the Robina Institute's Sentencing Guidelines Resource Center and the Institute's Criminal History Enhancements Project. His scholarship examines Minnesota and other states' sentencing guidelines, punishment, and proportionality theories, criminal procedure in the U.S. and abroad, and comparison of sentencing law and practice across U.S. states and between the U.S. and other nations. He is the author, co-author, or co-editor of 9 books,
over 85 articles, essays, and other writings on these topics. So he's somewhat of an authority. Professor Frase's presentation, quote, "Can sentencing guidelines commissions help states substantially reduce mass incarceration?" Will examine the strengths and weaknesses of Professor Zimring's proposal that sentencing guidelines commissions could, if given additional powers, help states substantially reduce their bloated prison populations. Professor Mark Bergstrom has been the executive director of the Pennsylvania Commission on Sentencing since 1998. He's an associate teaching professor of sociology and criminology at the Pennsylvania State University, an adjunct professor at the Duquesne University School of Law, and an adjunct faculty member at the Villanova University School of Law. His presentation, Super Sentencing Commission, The Hope and the Reality, will explore the benefits and costs of the Pennsylvania Commission on Sentencing's efforts to expand its work over the past decade to include risk assessments, resentencing guidelines, parole guidelines, and recommitment ranges. Please join me in welcoming both Professors Frase and Bergstrom. And Professor Frase, first to the podium.
All right. Hey, it worked. All right, well, I want first of all thank the Law Review for organizing this conference on this important topic and bringing in such great people to inspire us. And I don't know whether, I'm guardedly optimistic about not, I guess, on the prospect of mass decarceration, but maybe something meaningful, at least over time. I mean, these are difficult questions. And a lot of what I'm going to say has already been alluded to, so maybe that will help me to get through these slides. I'm going to focus on, because what I do is particularly sentencing guidelines in Minnesota and other states, to a lesser extent the federal guidelines. And so I'm delighted that Professor Zimring has given Sentencing Guidelines Commissions a major role as part of the project to roll back mass incarceration. And I think I'm a strong believer in those commissions, especially if they're well designed and well funded, as they are in a few states. I think Minnesota qualifies for that. So anyway, I'm going to try to both emphasize what I see are strengths in these proposals, some problems they may run into. The devil is always in the details, but we can probably work through the problems. I want to emphasize the ways in which sentencing guidelines commissions have already helped a number of states, including Minnesota, to limit growth in prison populations. And even though Minnesota's prison population actually has grown a bit faster in percentage terms than the national average, we're still one of the lowest incarceration rate states, and we have had a major increase in the number of felony convictions. So you got to take into account what's coming in the front door. It's not all sentencing. It's also, as we discussed this morning, prosecution decisions, to some extent crime. I want to emphasize that because of those important roles that they're already playing, that if we're going to give them new roles, we want to make sure we don't interfere with the good work that they're already doing. To get down to specifics, there are 3 new roles that are envisioned for sentencing guidelines commissions. First, to give them the parole releasing power, case-specific prison release decisions rather than a parole board. Secondly, to create state grants for local community-based sentences in lieu of state prison sentences, and charge back against those grants if the given local jurisdiction is sending people to state prison who state policy has decided don't belong in state prison. And finally, collecting and publicizing data on specific local criminal justice decisions, policies and practices, especially by prosecutors, that help to drive up prison commitments and prison durations. So let's look at, first of all, sort of the overall big picture of all three of these proposals. I think that a major strength is that they are based on, they make use of sentencing guidelines commissions. Because those commissions have certain strengths which can help them better than any other agency tackle the problem of mass incarceration. We've been talking a lot today about the Zimring and Hawkins term, the correctional free lunch. Let me just emphasize that again, the idea that local decision makers, judges and prosecutors, to some extent correctional authorities, are spending state money. They're sending people to state prison. They have no accountability, no cost. Whereas if they keep the offender in the community, there is a local cost. So it's a complete disconnect in terms of decision power and budgetary responsibility. An agency at the state level can address that better than any local agency. Sentencing guidelines commissions are designed, like most administrative agencies, to be relatively independent of direct electoral pressures. So the members aren't elected, they're not under the direct control of elected officials, can't be fired if the governor doesn't like the decisions that they're making. So that gives them some insulation. They can be broadly representative. So in the last three bullets here, I emphasize the word can, because it kind of depends how the commission is created and defined. But a well-designed commission has got members of all the major constituencies in the criminal justice system, which gives them a better perspective, a broader perspective than any of the principal branches of government. They, like all administrative agencies, they can, if they're properly designed and funded, collect data, acquire expertise. They can take a comprehensive, evidence-based, long-term perspective on criminal justice issues, as opposed to not evidence-based, gut, as opposed to crime of the week. Things that get the headlines don't necessarily make good long-term policy. And because they're statewide and the rules are relatively transparent, sentencing decisions are more consistent and predictable, and therefore more fiscally responsible. We know what it's going to cost if we raise this penalty. And I'll come back to that point later because it's very important. There are some questions about how well this might work. I'm certainly willing to give it a try. It is true that no commission has ever been given any of these three roles, to my knowledge. It's also true that very few commissions have had, in any way, a major role in reducing mass incarceration, but I want to cite two counterexamples to that. One, the older one, is in North Carolina, where in the earliest years of the North Carolina guidelines, and they have a system that's, I think, well-designed, like Minnesota's, has a lot of similarities. In the first 4 years of their guidelines, the prison rate went down 12%. In the 4 years before those guidelines became effective, it had gone up 41%. So they turned that around. That was because of their guidelines. More recently, the state of Alabama in 2013 decided that if they didn't do something, they were going to be in the same boat as the state of California under a court order to greatly reduce their prison populations. And on top of that, they had no room in their jails. So they knew they had to do something. So they made their sentencing guidelines, which had previously been advisory, legally binding for nonviolent crimes. And in the 4 years after that we have data for, 2013 to 2017, the prison rate per capita per 100,000 went down 25%. So that didn't just stay at a plateau, it drove it down. So these rules do matter, commissions do matter. Now, there is still the problem of whether additional duties will overload the commissions, and they may not get enough funding to do it right. You get what you pay for, and guidelines commissions are a good buy for the amount of money it takes. There is finally the problem that parole release decisions, grants and chargebacks, revealing who's making the decisions that are sending too many people to prison. Those are all contentious issues. They're going to attract a lot of attention. There's going to be some risk of pushback and interference with the commission's political independence. So, but you know, if you can't stand the heat, get out of the kitchen, I guess. Let's look at the three proposals and sort of pro and con. I think that the first proposal to have the commission rather than a parole board make these prison release decisions is a good idea for the reasons that are shown here. A state level agency, any state level releasing decisions are going to even out local disparities, and also it gives greater emphasis to the state impacts if we're making these decisions with a state body, and it's a politically independent agency, unlike the parole boards, which are not politically independent by any means. And as Professor Wrights just pointed out, they can and do suddenly slow down or stop releasing people. Commission, as long as it remains relatively insulated from short-term political pressures, as they have been up to now, is better equipped to make more consistent, less punitive decisions. The timing, arguably, if you make a prison duration decision at the sentencing stage, the crime is still sort of fresh in people's minds. There's a sense, well, we need to denounce this kind of behavior, and if you have so if you wait some time, arguably that will allow for more reflection on how serious this crime is, but also to consider changed circumstances. And people do change in prison. And not just because they're older, although that's the principal reason. And commissions can develop guidelines for release decisions and for what to do about violation. As been pointed out already, revocations to prison, either from probation, which is pre-prison, or from parole, which is post-prison, revocations of people who are violating the conditions of their supervision are a major contributor to mass incarceration. And yet those decisions are not really guided and structured very well. Commissions, that's what they do. They make rules to guide and structure these decisions. So again, there are potential issues with this. If you just look at the period up to the peak mass incarceration, which was 2007, 8, 9, is roughly when the national rate peaked. The jurisdictions that retained parole release discretion, whether they had guidelines or not, tended to grow faster. You would think, though, that's a safety valve. You let people out, you'll grow slower if you have that backdoor release. But it didn't work out that way. Now, whether it would be the same, whether it is the same now that we're in the past peak period, that's a separate question, and something I'm really just beginning to look at now. The patterns do look a little bit different, although to some extent they reflect the earlier pattern. If you had jurisdictions that were slowing their prison populations up to the peak, well, then you would expect they've got less of a peak to climb down from. So they may not be the jurisdictions that are going to decline as fast as other jurisdictions. Second point here is that guidelines commissions are generally creatures of the legislature and subject to legislative oversight and always concerned with being overruled or losing some of the delegated authority that they have. So unless the legislature says, we want you to use prison release decisions to lower the prison population, I don't think most commissions are going to try to do that. So it's going to require a legislative commitment to doing this. And in Alabama, that was true. Legislature said to the commission, do this. They did it, and they got a major reduction. There is the problem, there was a few years ago a lot of rhetoric about truth in sentencing that says, look, if somebody gets a 10-year sentence, they shouldn't be getting back out on the street in 1 or 2 years. That's false advertising. So if whoever's making the decisions at the back end, whether it's a parole board or a sentencing commission, if they're making substantial reductions in prison sentences, there's going to be that pushback again. Maybe it won't come back, but we saw it once. And when you have backdoor releasing option for judges, they're tempted to look tough because they can say, well, this isn't, the parole board take care of it later. I just want to show how serious this crime is, so I'm going to give him a 20-year sentence. When you don't have parole release at the back end, the judge has got to take responsibility for that. It's real time. It's not just a symbolic gesture. And finally, there are other ways of achieving some of the advantages of parole or back-end release discretion. You can have guidelines for the judges in terms of duration. You can give them risk tools. Good conduct credits can and do take into account not just disciplinary rules, but programming. Did he cooperate with the assigned programming in prison? And if he did, he gets more time off. So that can be built into that formula. And as Professor Wright has shown us in his model penal code work, that we could have more selective resentencing and emergency release options to deal with things at the back end. So there are other ways of doing the release decision rather than at the back end. Second proposal, the grants and chargebacks to encourage non-prison sentences. This is a good idea. Again, the correctional free lunch is a real serious problem. And a lot of communities just don't have the money for more substantial community-based sentencing. They need state financial support, but they also need accountability on that. So the chargeback is a way. It's not like, to totally abolish the correctional free lunch, I guess you'd have to tell each local jurisdictions, well, you're going to pay for the prison beds you use. They can't afford it. But if we give them grants and then charge back against that if they're sending the wrong people to prison, that incentivizes them in a way that they aren't now. They got something to lose if they're not following state policy about who should go to prison. Again, for all the reasons I said before, guidelines commissions are the best agency to administer something like this. State level expertise, broad-based membership, and so on. How do we actually do this? Well, I think at least on paper, you can say, well, this county has got this caseload, so we know how many cases they have. Here are our state policies on who should go to prison, who should be in the community. If they go to prison, how long they should go. So we have some sort of benchmarks for how many prison beds a given jurisdiction should be using. And if they're using more, we charge back against them. And again, the commissions, because their business is issuing guidelines, they could have guidelines not only for structuring probation conditions in the first place, but again, structuring revocation decisions, a major contributor to mass incarceration. So we can draw on their guidelines drafting expertise. Again, some potential problems here. I said a minute ago, we can figure out how many beds you get by state policy about who should go to prison. But state policies are based on the typical case. And guidelines, the essence of guidelines is that you can depart either up or down based on atypical circumstances. And so I can imagine a case that County X is about to lose some of its money because they sent too many of the wrong people to state prison, and they say, no, we didn't. We have an unusually high rate of aggravating circumstances and or a low rate of mitigating circumstances. We get more of those state prison beds than the average county would, or the URT formula would say that we would. So then we're going to have to assess whether they really do have more of those kinds of unusual circumstances. That's going to be time-consuming and staff-intensive. Minnesota did it in the early years, but only in the early years and only for some counties and only on a very conservative assessment basis. So it's going to be a little tricky. Especially when we're saying, do they need these prison beds for crime control purposes? Well, how do you assess crime control purposes from court records? That's going to be pretty hard for the commission to do. And there's always debate about how many prison beds are needed for deterrence are needed for incapacitation of dangerous offenders, there'll be debate about that. But I don't think these are insuperable problems. Finally, the third proposal is to shine a light on the people, the judges, especially the prosecutors who are making decisions that are sending lots of people to prison. And to focus on not to pick on the prosecutors, but they are very, very important officials. They are sentencing officials in a very real sense. When they charge mandatories or high severity offenses rather than an available lesser severity option, how many counts do they charge? What kind of sentence recommendations do they make? Do they use diversion options like drug court, more or less? Huge impact on how many people go to prison and with what prison terms. So if you publish data on that, especially if it's it's not only county specific, but maybe even assistant prosecutor specific, we have an idea, okay, this county or this particular group of prosecutors in the county is using up more than their share of prison beds, is costing the county money if the chargebacks are made. That generates some pressure, both on the chief prosecutor, and then the chief prosecutor turns around to the line prosecutors and says, hey, you guys, get in line. You're out of line, in theory at least. And then finally, some people, some local actors do care about their contribution to mass incarceration, but they don't know what it is. So without data, those impacts are invisible. Downsides or potential problems of this. It is going to be hard to get some of the data because prosecutors tend to keep the data to themselves or they don't have any. So that may be difficult, but I think that's can be overcome. Now, some, as John Pfaff suggested this morning, you can't assume that outing some of the greedy prosecutors that are using more than their share of prison beds, is going to incentivize them. Some of them say, "Look, it shows how tough I am." Good, yeah, I guess some will, but. Counties losing money, it may be that the money will prevail. But a broader problem is that it isn't just a few rogue prosecutors that are using up too many prison beds. The increase in the number of cases filed, the number of felony convictions is a national phenomenon, at least to the extent that we have data on that, across the board. So then the question is, how many felony convictions is the right number? That's a difficult question. I'll come back to that at the end. So anyway, I don't know, I haven't seen any cards lately. What? Oh my goodness. I went through all those cards? How did I not see you? Okay. All right, so I have to wrap up. It always takes longer than you think it's going to. So anyway, as explained in these two slides, guidelines commissions have already done a lot, especially in the parole abolition states, to restrain growth. Especially one of the things that's sort of a parallel to the geographic correctional free lunch is the temporal free lunch. If you make a 10-year sentence into a 20-year sentence, the cost of that is paid for 10 years in the future. So the people who make the decision now don't really have to take any responsibility for it. There are ways for guidelines commissions to help in other ways, including some lighter versions of Zimring's proposals. I like the idea of focusing on the high rate states because if you had a much lower punishment scale, it could still be proportional to the offense. And what we know about crime control tells us that we wouldn't lose anything in terms of effective crime control. So anyway, as I said, we don't know for sure whether things work as well on the way down as they did on the way up to mass incarceration, but it's worth a try. There is still, I think it's fair to say that Americans cannot be 5 times as culpable or 5 times as dangerous today or at peak incarceration than they were 50 years ago. On the other hand, some people think that we weren't taking some cases seriously, so we maybe can't even argue for going all the way back to the 50 years ago rate. I think, I may have misread it, but I think Zimring suggests a 300 inmate target. That would be a 1/3 reduction in our current national rate of 450 per 100,000. I think it's reasonable, I think it's achievable, and I think commissions can help us attain it. Thank you.
It works. All right, well, good afternoon. As I look at the agenda, I think I am the last presenter before Professor Zimring responds to everything. So I guess the good and the bad of that is that a lot of the stuff's been covered already, so I'll try to skip over some of that, and we'll try to move this pretty quickly. So I'm going to be talking, first I want to thank the organizers of this symposium. I found this really interesting and thought-provoking today, and I want to thank Professor Zimring for his manuscript. I've known Professor Fraze for a long time, and I'm going to echo a lot of the things that he said. But I'm going to come at this from a little bit different perspective. I run a sentencing commission in Pennsylvania, and so I think my comments are much more from the field or practical, and I think there's both positives and negatives. And as with Professor Fraze, I'm going to focus on Chapter 7, which is the restructuring of the governance of imprisonment. So I think the starting point, as I was looking at the chapter and the manuscript as a whole, were some of the purposes of sentencing. And I think when we think about, at least sentencing commissions think about purposes of sentencing, we also often think of it at the sentencing point of view. We think about what judges are thinking about at sentencing. So we think about retribution versus utilitarian purposes. And I think that's great, but I think a real benefit of the manuscript is thinking more broadly about those purposes of punishment, the symbolic values like the adversarial success and the reassurance of victims, and then those counterweights, the public cost and excessive severity. So while at sentencing alone, when you're thinking about purposes, there's a lot of conflict, a lot of different judges have different views of what they're trying to achieve. Then combine that with these other factors that have to be considered, and you can understand why you'd have very different outcomes and different approaches to sentencing. And so, as he said, every choice is a compromise. I think as we look at some of the other issues that he raised, I think some of the takeaways are there's a lot of different players at a lot of different layers making a lot of different decisions for a lot of different reasons. And so I think these are the four key sort of zones that Professor Zimring identified, and I think these are the ones we have to think about in any kind of solution moving forward. So certainly the level of government, the interaction between state agencies and local or county functions, the focus of the decision, whether we're talking about individual offender information or decision-making versus more policy-level decisions. Certainly the cost is a big issue, and as has been discussed, if you have a free ride, you don't have to be very concerned about, what you rack up it as the costs. But different players in the system have more of a sensitivity to that, and we have the whole issue of cost at the local level versus cost at the state level. And then I think timing's the key thing. What decisions are and must be made by the court at sentencing, what decisions are made later in the system. And although we've talked a lot about an indeterminate system where parole is sort of that second player, I think we have to think more broadly about other types of later in the process decisions. So there's been talk of second chance, and so we can certainly think about roles of courts in reconsidering sentencing, but there's also the role of just clemency generally. Pennsylvania has a board of pardons, which for probably the last 50 years have done little or nothing, and all of a sudden with new players, there's new energy. So we have both pardons and commutations that are 180 degrees from what they were 5 years ago. And part of that is the elected members that are on the Board of Pardons, and part of it is their decision to hire a former inmate as the secretary of the Board of Pardons. There's been a sea change in what we consider and what is considered for clemency in Pennsylvania. And so when we're thinking about these back-end changes or revisits, I think we can think about all three of those places. The court's role in that, a paroling authority's role in that if you're indeterminate, and then executive clemency. So the model that's put forward is what's described as fully administered law of imprisonment. And as Professor Fraze mentioned, there's sort of these three parts. So the one part is power over individual sentences. The second part is all about distributing funding to incentivize different habits and particularly either diverting people from state prison or down to county jail or out of the system totally. And then the third is really what I see as like an information system about trying to make sure we're shining the light on all parts of the system so that no one's hiding, that all the decisions that are being made are out in the open and they're held accountable. So in Pennsylvania, we're, as a sentencing commission, we collect a lot of data. We have about 150,000 sentences a year reported to us, and we're really good at releasing that information. And we release judge-specific information, offender-specific information. I mean, we're very open and transparent about that because we think the Commonwealth's paying for that. Our obligation is to release the information, and that's what we do. But I think we can talk about the same role of that in providing information or trying to dig for information about other practices in the system. And if prosecutors are negotiating pleas in 90 or 95% of the cases, that courts are either accepting or rejecting, then I think that's really an opportunity to look at that and say, how can we bring that into the process, the information process? So I think there's a lot to be said about some authorization, about transparency in a lot of those areas and accountability. So I wanted to dive just a little bit deeper in the sort of the business of sentencing commissions and sentencing guidelines, because I think this is a really it's the initial, but also a really important area for change. And certainly at the sentencing guideline levels, 3 areas were identified: diverting drug offenders, trying to move people at the margins from state prison down to county jails, and then also sort of thinking back, if this were 1970, what would be different? And trying to sort of reset some of what we're doing. I think the first one, diverting offenders, drug offenders, or categories of offenders, I think is really important. I had the great benefit of taking a trip to Europe a couple of years ago. It was a prison junket. I don't know if that's a great thing, but we spent some time in the Netherlands and in Germany looking at their practices. And what you really appreciated was the social safety network and how treatment of drug and alcohol or mental health disorders, other things like that, was just not a criminal justice function. And so, you carved out a huge chunk of the criminal justice system and just put it over where it should be in public health. And so that makes a huge difference. And when I come back and I look at what we do in Pennsylvania, I think about the mental health system. And we've been working on, and maybe you have this here, a sequential intercept model, where you're trying to look at the interface of the mental health system and the criminal justice system. And you're saying, if someone's acting out at 3 o'clock in the morning, what's our response? So at every decision point, first responders, initial court hearings, and so forth through the system, you're trying to develop this sort of action plan or this discussion about, are we the right people to do it? Does this case have to be in the criminal justice system? And so I think there's a real opportunity, if you are in a planning stage trying to think about how you direct your resources and how you make the best use of resources, to think about whether that thing is the role of the criminal justice system, or is there some other government actor that should be doing that? And we focus on it in the mental health system because that was a big growth area. County jails, state prisons, have these huge increases in psychotropic costs because of those people they're dealing with, and they don't deal with them very effectively in those settings, and those people do worse in those settings than other individuals. And so I think it was a really good opportunity to really get people together and think about how we can really redirect these cases to the mental health system or to behavioral health. And I think the same approach is important with drug offenses and other offenses, trying to sort of figure out whose world is this, and it probably isn't ours, or at least a lot of it isn't. And I think that's a really positive thought in terms of how do we unring that bell, or how do we move this back in another direction. On the marginal cases and the sort of database, I'm going to come back to that because I'm going to sort of provide some context in what I've seen, going back to the 1970s. It was a fun trip, but I have some little sort of takeaways from the 70s, some echoes from the past, and I think they're consistent with what's been outlined as the path forward. Let me move to the parole and administrative release side, sort of that back end side. One of the things that I think is an important point, and this picks up on Professor Wright's point regarding the use of parole and sort of that back end kind of review of cases, and that is if the majority of jurisdictions in the United States are indeterminate, so they have some type of parole system, what you have to ask is, what's the structure and nature of that parole system? I can tell you in Pennsylvania, we have parole. We have a whole structure around parole. But our starting point is, in Pennsylvania, there is no right to parole. So a court sets a minimum term and a maximum term, and there is no right to parole before the min, and even after the minimum term, when someone's eligible for parole, then the presumption is not that the person is paroled. The presumption is that the government's going to sort of lend grace to this case to parole someone. That's a whole different view of the world than many other states, where the presumption is you're paroled at your minimum term or whatever it is. So when we're thinking about parole or the use of that function, that back-end function, to correct disparity, I think we have to think about how that's structured. Because I know in Pennsylvania we'd have to do some reworking of that, because that's not the sort of the place we come from. So something to keep in mind. But I think whether it's parole or commutation or some other second look approach, I think trying to look at how you address changing circumstances and trying to address older offenders and other kind of medical issues, things like that, all make a lot of sense, because it just doesn't make any sense at all to house a lot of those people in a correctional facility when that's not really, certainly not a harm to the community. So here's the echoes of the past, and I'll go through this quickly, but the idea is to try to think about what were some of the takeaways from back in the 60s and the 70s that I think are consistent with what's being suggested today. So the first thing is what was referenced this morning, the Johnson Commission on Law Enforcement and Administration of Justice. Professor Bloomstein might recall something of this, and so just a couple takeaways from that, but. One of the things was the commission recognized the competing purposes of sentencing, but they also recognized the role of prediction. They said that, judges are sort of in a prediction business. And so when we're talking about risk assessment and things like that, we're really getting to that idea of if part of your job is to sort of make a guess or bet on whether someone's going to reoffend or not, or whether someone's of risk to the community, how do you do that? If you look at the research on risk assessment, they talk about these 4 generations of assessments, right? And the first one is professional judgment. That's what judges do today. The second one is actuarial assessments, where you're taking advantage of the data out there and you're trying to sort of look at trends. And what the research says is the combination of the two is better than either alone. So having a judge make decisions informed by some information about what do the data tell you is a pretty good approach. You don't want to use a risk assessment to make the decision. but it's not a bad thing to use it to inform a judge making a decision. And what we're trying to do in Pennsylvania is use the two of those to then identify cases where it's worth doing a deeper dive, what you call third or fourth generation, where you're looking at risk and needs and responsivity, case management, and using that to figure out what's the best kind of intervention in this case. So if you think about that kind of approach and say, let's do an assessment, let's give that to the judge, let's use that to decide which cases it's worth maybe slowing down the process or investing in more information so the judge can make a better decision, then you have two positive things that can come out of that. One is what was suggested earlier, which is divert cases, move cases out of the system. So think about low-risk cases. You know, what the research says is low risk, low needs, less is more. You know, we do too much probation, we do too many conditions, do less in those cases, save money and have better outcomes. But at the high risk case, there's, I think, a problem with relating high risk to incarceration or more incarceration. And what we found was that's not at least the purpose that we're looking at. What we find is if someone's high risk, our state has enacted a whole bunch of alternative programs that are underutilized. If you think about problem-solving courts, you know, drug treatment courts, mental health courts, veterans courts, things like that, what the research says is those are particularly useful for high-risk, high-needs cases because you want both community supervision and you want appropriate treatment for those people. And if you put people in those programs that aren't high risk and high needs, you're probably either wasting resources or you're not going to have great outcomes. Well, how are you going to know if someone's appropriate for those kind of programs that you're putting a lot of money and energy in if you don't do some kind of assessment? So I think there's an argument along the lines of what was mentioned earlier about thinking about the way that you incorporate risk and needs into sentencing guidelines, sentencing decisions, things like that, to help courts think through the options courts have and decide when treatment or some type of special program is a viable option. So here's some of the echoes from the past. Certainly, some of you may be familiar with Judge Marvin Frankel. When he was talking about the establishment of sentencing commissions, he talked about the choices available to judges and the need for direction from the legislature on the purposes and objectives of criminal sanctions. Well, I think we still need that today. We in Pennsylvania back in the 90s tried to articulate purposes of sentencing within our guidelines. But when we tried to then link those to certain types of offenses or offenders, we got killed. So it's a very difficult thing. People view these things very differently. But we need to sort of reach some consensus about what we're trying to do. If the consensus is we shouldn't lock so many people up, we need to get some high-level buy-in to that. And I think that's missing. We're sort of out all doing whatever we want to do, but I think this calls for a really consistent plan. I'm going to move through some of these slides to sort of cut to the chase, except I will show a couple of contemporary views here. Professor Tonry is here earlier today. He did some thoughtful work in a lot of areas, but in one area he looked at indeterminate sentencing states and sentencing commissions. And he was talking about the way of reconciling or working those two together because you have the structure up front to try to address uniformity, proportionality, things like that. And on the back end, you have a mechanism to think about those second looks. We have Professor Steve Chanitson at Villanova University School of Law, who was a former chair of our commission, who talked about a sort of a structure that he called indeterminate structured sentencing, the idea of having a commission that did both sentencing guidelines and parole guidelines. Sort of sounds familiar. And then we have our own Professor Richard Fraze, who has done a lot of work on sentencing and sentencing guidelines and sentencing commissions. But one of the things that I think has been key is the work he and the Robina Institute here have done in the area of criminal history. If we think about all of these recommendations about improving sentencing decisions, the one thing that Robina and Professor Fraze have really focused on is how much weight we put into criminal history, how that inflates our sentences, And that's the same thing that we're worried about at the back end, old offenders in prison or people that are at low risk. So it helps to think about how we look at redemption and other things like that to really pare back the sort of the hammer of the criminal history. We have Professor Reitz, who has done a little bit of work with the ALI on the model penal code sentencing. And really, he's already talked to a lot of these issues, really important issues in terms of the role of sentencing commissions and sentencing structure. And if you're going to have parole, how you sort of use that, or how you use other kind of back-end corrections or revisits of sentencing, important stuff. And then Professor Bloomstein takes us back to where we started. That's the diagram from the Johnson Commission. And keep in mind, that was sort of the starting point of thinking about this as a criminal justice system, not just a bunch of individual players. But the big takeaway was what he did as Director of Science and Technology, because I think he really focused on the role and the importance of things like research and development and really helping to codify a lot of what we do. We know a lot more today about what's going on than we did in 1970 because of all this kind of work. And we know it across the system, and we understand the flow of the system way more. The problem with that is we know a lot more. So we can use these tools to really crank up incarceration if we want to. And if we do it smart, we can reduce it back. I'm out of time, but I'm going to take like 1 minute to try to close this. So I think there's other things that we have to think about, the role of guidelines and so forth. One thing that I think is missing in this conversation that I have personally experienced in the last 10 years as we worked on risk assessment is the role of media and social media. It's a different world today that informs what we do and how we do it. And before it was media, which was somewhat controlled and stable, and now it's social media where something can get out there and you can have 200 people show up for a public hearing with sort of some information that may be right and may be wrong. And that can really influence the way we're moving. So I think those are important things. I'm going to just close by saying I think in Pennsylvania we may have an imperfect prototype to look at. We have mandatories, we have responsibilities for sentencing and resentencing guidelines for parole, reparole, and recommitment ranges, and for risk assessment at all stages of the system. We are working on revising our guidelines to look at that criminal history, to think about more targeting of the use of sentencing dispositions and duration, including duration of probation. And we are required, if our justice reinvestment or recommendations go through, to provide interactive information along the lines of what Professor Fraze has talked about. And we have in the past, and we would in the future, have a responsibility to link our or any funding from the state to the counties through the utilization and compliance with both our guidelines and some sense of compliance with the practices in place. So with that, I think I will close out and turn it back to the professor.
Okay, we have 3 questions, maybe room for one more if someone feels inspired. The first question is for Professor Fraze, but I think Professor Bergstrom can answer it as well. Your presumption is that everyone would agree that there is a problem with mass incarceration. And this is we'll start with Professor Fraze. Do you believe that it is the case that everyone would agree that there's a problem with mass incarceration?
No, but a lot more people than believed it even 5 years ago. It is interesting. We've heard a lot earlier today about progressive prosecutors, and they seem to be split at this point. I don't know if there are, I suppose there are progressive police chiefs. We haven't heard as much about them, but they're the ones that are making the arrests, so that's where it all starts in law enforcement.
And I guess we haven't heard that much today. There was a mention of the Right on Crime movement some years ago, and it must be 7 or 8 years ago now. Fiscal conservatives, libertarians began to notice that criminal justice and punishment is a wasteful big government program. And it's not cost effective, and that's still there. But it's interesting that there's still people holding out and thinking. There was the gentleman in the audience earlier today who seemed to think that the answer is always more prison, and that if you don't give more prison, you're not respecting victims, and all that thinking that gave us mass incarceration, it hasn't gone away.
So I don't think there's consensus on it. I think there's consensus in pockets, but look, Pennsylvania is not a good government state. I always look to Minnesota as a good government state. We're not. And there are plenty of people in Pennsylvania that are quite sure that we don't have mass incarceration, we have correct incarceration. And just through, one of the things that has delayed our justice reinvestment process, which would try to do some reductions, especially in the back end with more presumptive parole and other things like that. One thing that is stalling that is efforts to reintroduce certain mandatories following the Aileen repeal of mandatories. And that has sort of hijacked that legislation. So I think, one of the most difficult situations our commission is in is trying to argue or trying to sort of set a fire under people that there are concerns about the level of incarceration or the use of resources, because there are plenty of people that don't see it that way in the legislature.
How can other stakeholders impact sentencing, such as probation officers conducting pre-sentence investigations or making recommendations for probation violations? I think that's an example. So what role can other stakeholders play? And I assume by other, beyond the commissions themselves.
Yeah, I can give you an example. Again, this work on risk assessments. Our Council of Probation Officers statewide was not particularly supportive because they were concerned about more work and unfunded mandates and things like that, even though they were really focused on trying to build a greater capacity for evidence-based practices, including risk assessments and pre-sentence investigations and so forth. But there were certain chief probation officers, and particularly those that came from the juvenile side to the adult side, that had this history of appreciating the benefits of that type of information in informing disposition decisions, but they became really these exemplars of best practices, and they've been really helpful. And I found that with judges too, and again, judges that had been in juvenile court and had the experience of best practices there, coming over to criminal court and just trying to think about how you can bring that to scale, because it's all the criminal side is all about scale. The numbers are huge and the resources are limited. So how do you do that? And I found those crossovers from the juvenile side have been really helpful examples.
You want to take a stab at that one, Richard? Okay. What about using due process protections, for example, higher standards of proof, higher thresholds of proof in probation, parole, revocation hearings, especially parole, where hearings are done in jails before Department of Correction hearing officers?
Well, and another piece of that is but it all depends on, I guess, or largely depends on what courts are going to insist on. Occasionally, the legislature or the Criminal Rules Committee will do something, but it's usually when the court says you have to do it, and that depends on who the judges are. So I'm not very optimistic enforcing or more strictly enforcing limits on inhumane prison conditions is another way to raise the cost of mass incarceration and incentivize the system to use less of it. And I guess if we had some countries do a lot more with unannounced prison inspections, and that's a way of building the record better to enforce humane prison conditions. Yeah, I guess anything that pushes back. Instead, it seems like, as was pointed out, we kept adding more and more severe penalties and mandatory penalties. The defense had legal issues they could raise, and they waived them.
Do you want to try that?
No, not even close.
Anything else from the audience? Otherwise, I will conjure a question. Nothing from any of our other guidelines folks here? Okay. And this may be my misreading of what you were talking about, both of you actually. But if you move parole release decisions away from parole boards to sentencing commissions, then you're presumably shifting jurisdictionally, at least to some extent, from an indeterminate frame to a more determinate frame, which necessarily would mean fewer parole decisions overall. But even in states like Minnesota, where we've had a guidelines commission for quite a while, you are still dealing with dozens, if not hundreds, of parole decisions each year. Is a guidelines commission really the best body to undertake such individualized inquiries?
Well, I'm not sure if it is or not, but we have it. So in Pennsylvania,
and how does it work?
Well, and here's where we are in the process. So we've had a mandate for sentencing guidelines since the late 70s, and we received a mandate for parole guidelines about 10 years ago. And so the first thing is institutional issues, right? The parole board wasn't thrilled about us getting into their space. So that was, there was a lot of trust building, things like that. We are now at the process where we have draft parole guidelines that are under discussion. And here's the reason and here's the approach. So the idea was the Sentencing Commission doing both sentencing and parole guidelines. There's opportunities for coordination and so forth. Which cases are going to be fed to the parole board because they'd be state prison cases and so forth. But the parole board's a good feedback mechanism in terms of who are the people they're seeing that either are inappropriate for state prison or that the duration doesn't make any sense at all. So there's a benefit in an indeterminate system of better coordination between the two decision points. Keep in mind that the commission is creating guidelines that are used at individual levels, but based on policy decisions. So you're still going to have the board looking at the file of the case and really applying the guidelines to that case. So there's this. It's not unlike what we'd expect at the sentencing process, where you have guidelines that are applied to a case, but then the judge is doing an individualized sentence. The only difference that we see that is difficult is that, at least in Pennsylvania, we have 9 parole board members, and for certain cases, you need a sign-off of 5 members for violent cases. And so just the logistics of thinking in terms of not so much having them do it, but how do you present that information to the public? Because we're very transparent about what we do. The parole board, not so much. And so our job is to try to figure out how we can fairly present what they're doing to the public when you have multiple decision makers instead of a single decision maker.
Was your question also about just how a sentencing guidelines commission would make all those case level decisions?
Well, I mean, the sort of the logistics, and from an efficiency standpoint, I mean, I would think it would be.
Yeah, well, and so I guess I'd say 2 things about that. One is there are administrative agencies that do case level adjudication.
There are.
And sentencing guidelines commissions have not been among them up to now, but I don't know if there's anything inherent in that would prevent them from doing it. And the other thing I would say is that if that just seemed to be too overwhelming a burden for a commission, you could have a system of appeal to the commission from a denial of resentencing, a denial of parole, so as that they're not making all the decisions in the first instance.
Okay. No, that's a point well taken. I will say, and there are those in here who probably realize this, our Department of Human Services makes hundreds of thousands of individualized decisions in in licensure waiver cases each year. And it is an administrative agency that is quite ill-suited to be making such, and as a result, few people have licenses. But with that, thank you very much to both of you.
Thank you.
All right, everyone, thank you so much. Hang tight, our last panel with Frank Zimring is about to begin. We plan to wrap up by 4:30 or a little before.
Okay, this last portion of the day will be one where we give Frank Zimring the chance to respond to everything that has been said since 8:30 a.m. this morning, which he's actually capable of doing. Wait until you see it. But before we turn to that, I just want to thank the Law Review and especially lead Symposium editor Sarah Troutman, who is over there, who has accepted responsibility for running this event, and it could not have happened without her. So, Sarah, thanks so much. Now, I don't know if I have to introduce Frank, because all day long you have heard about his stature in the field of incarceration and the substance of many of his ideas. Although I will say that his presence in the field of incarceration, mass incarceration, is just one part of a much larger body of work that he's done in juvenile justice, drug control policy, gun violence, as we heard earlier, why crime rates have been falling to the degree they've been falling. So we could have just as easily have had a conference on some other aspect of his work, and it's just nice to note that last week Frank won the Nobel Prize of Criminology. It's not called the Nobel Prize; it's called the Stockholm Prize. I think mostly for your work on firearms, or that was the focus of the committee. So he is pretty versatile, but we are about to hear from him today on what we've all been talking about all day long. So, Frank?
I've had a very long career, and during that long career, rarely has it been the case that I have regarded the prospect of an all-day conference in a law school as a source of delight. This one was an exception, and I want to talk a little bit about why. In the first instance, the University of Minnesota is one of 3 or at most 4 law schools in the United States which has attained intellectual respectability in the research on criminal justice policy and criminal law. You know how many law schools are out there, so you do the math. But
3 or 4 of the people that we've heard today are local talent, but they're local talent of national renown. And added to that was a sort of a dream team of critics. Al Bloomstein has been in this business longer than I have. Rachel Barco, my envy there is, why are there so many chapters in this book? The problem is that this is the last book I'll ever write on prisons. Not her problem. And she has become, in her generation, a leading scholar not only in criminal law and criminal justice administration, but on linking that to legal perspectives on administrative law and government. And that turns out to be the main event for the subjects that we've been talking about today. There are Bob Weisberg of Stanford, who came over the airwaves, has been a fabulously intelligent student of the rhetoric and analysis in this area, of just substantial value to the rest of us. So it was an all-star cast. And I have the feeling now, not necessarily the one that I started with at 8:30 this morning, that the book and the principal author can survive it. Well, now about that book. It is an enormously ambitious venture. It attempts to look at 4 different issues, which I did not think the literature and analysis for all the concern on mass incarceration we've had done a sufficient job of unearthing. What happened in the United States between 1975 and very recent times? Why did it happen? What's going to happen next? And if that doesn't look like a lovely and desirable American future, what are we going to have to do to avoid it? Okay, the book didn't ask small questions. Didn't have all the answers either, as you've heard all day. But I think it has advanced our understanding. What happened between 1974 and 2007 in a single generation? The rate of imprisonment in the United States increased 5-fold, from under 100 per 100,000 to over 500 per 100,000. But if you were watching Professor Barco's graphs, that's just long-term incarceration and of adults. By the time you add jail populations, you're in the and add juvenile populations, you are in the middle to high 2 millions. So that's what happened, but how did it happen and why did it happen? There had never been any stable political order that had experienced anything like that 5-fold increase ever before. And from the standpoint of what we used to call correctional forecasting,
You could get very good academic experts to explain to you, maybe Al Bloomstein and I would have been among them, that what happened to us was actually an impossibility. Why? Because we don't have one system of criminal justice. We have 51 systems of criminal justice. And they all make separate decisions. So how could they all march to the same music at the same time? Governmental power was highly divided. But the first thing that would surprise the correctional forecaster is instead of the diversity of outcome that goes with 51 different systems, what we had for 35 years was unity. Everybody marched in the same direction, and that was despite the fact that the governmental centers of authority were widely dispersed. So that was the first big exception to the general rules of correctional forecasting. The second one is the magnitude of the changes. These weren't small changes. These were big changes. In the first 10 years, with no legislative change at all, not only did every state go up, but the average magnitude was a doubling of the correctional population, and we were just getting started. So there was high magnitude. The third characteristic that led to mass incarceration was something that I want to call momentum, and it's in the title of the book. Normally, what you expect following a large jump up or a large jump down in a system is some kind of equilibrium. It'll even out in the long run. But the big jump in year 1 predicted a big jump in year 2, in year 3, in year 4, and all the way to year 34. So you had unity of 51 different systems, you had high magnitude, and you had momentum. Now, the peak rate was reached in 2007, so we now have a full decade, not the draft that was read for this purpose, but the draft we have now. We have a full decade of what's happened since that peak in 2007. And instead of unity, and instead of large scale in changes, and instead of any particular magnitude of trend, what we have now is the old business as usual. That is to say, we have diversity with some downward tendency, but 35 states go down, 15 states go up. We have low magnitude, the average change, a tenth of what the average change was in the first decade going up. And we don't seem to have momentum, we've got equilibrium. Okay, why this huge and unprecedented move? What was happening in American government and society that lit this particular fuse? Well, there's a whole chapter in the book, not about what changed in the mid-1970s, but about American government, society, and resources generally that explains something about the high magnitude possibilities, but they don't explain what the big change was in the middle of the 1970s. Professor Bloomstein had showed us enormous continuity for the period between 1925 and the 1970s. What changed? Well, that is a fabulous mystery, which is only partially resolved in what we've been considering in this book today. And the one important motivating change I could find that fit the timing was almost too law professor cute to be a convincing one. What happened, what I said is, listen, numbers and statistics and projections, those were the kinds of things that people in graduate schools of business and departments of economics were dealing with for a long time. But law students don't learn to count. What happened in American criminal justice in the mid-1970s was prosecutorial management systems were finally introduced in the systems to tell people what case results were and to tie particular case results to particular branches and to particular prosecutors. But what on earth does that have to do with mass incarceration? Well, here's the problem. To be a good prosecutor in a system which depends on criminal trials, it's very easy to measure your effectiveness as an advocate. I mean, we all watched Perry Mason, didn't we? You go out there and you go into trial and you get a conviction. You get a what? In a what? Trial? No, what we had is what Norval Morris called the administrative law of crime by the mid-70s. And that is to say, outcomes and punishments were determined by plea negotiation. Okay, so you come home and you've had a full week as a prosecutor, and your significant other says, "How'd you do this week?" "I got some convictions." "Oh yeah, but those were all pleas." What do you measure your effectiveness in an adversary system with? Punishment stakes. I sent somebody up and got a 100-year sentence. Now, the problem with the birth of statistics and with punishment as a measure of adversarial effectiveness is that it's a little too cute. So Professor Weisberg said, but Zimring backed off from that explanation. I didn't back off from it. I was just a little embarrassed by it. But the reason I'm embarrassed by it is for the same reason we're going to be embarrassed for a long time when we find out what particularly did it. Because this is a huge effect that had relatively trivial causes in terms of the changes in government and society that could plausibly be linked to the mid-1970s. Okay. The next question the book tries to look at is what's going to happen next. And remember those projections. Instead of unity, we now have some diversity state to state. Instead of high magnitude changes, we now have low magnitude changes. And instead of large scale changes in individual years, we have sort of equilibrium possibilities and relatively modest changes. At best, by the middle of this century, which is another generation ahead, at best, we'll have an imprisonment rate of about 300 to 350 per 100,000. Well over half of all of the increase will still be around during the adulthood of the children who were born after the peak of American imprisonment in 2007. Is that inevitable? Of course not. What has to change? Well, these things are going to sound pretty pedestrian, but they're very important. Attaching costs at the level of government that makes punishment decisions for the use of imprisonment. That's a big one. The reason why trivial causes can have massive effects is because imprisonment is, for local government, a free lunch. That's important change number one. Important change number two is a political change well overdue in the United States. And that is determine the scale of imprisonment as a feature of government, but not as an aspect of criminal sentencing. The state agency that decides how many prison cells Minnesota should have or California should have is not making a sentencing decision. They're making a decision about the scale of imprisonment in Minnesota. Local prosecutors and judges can make individual decisions on sentencing, but that shouldn't become a decision on prison construction. Instead, what you have now is a situation where we simply add up all the people who have been sentenced to imprisonment and we decide that's the scale of imprisonment for next year. That's crazy and that's consequential. And that has to be reversed. And then there is a third thing which is of some importance, and that is that the criminal law need not be the first stop for serious governmental involvement with serious problems. Opioids and the treatment of drugs is a major governmental problem. There is no evidence at all that the criminal justice system is the best place to locate it. And what's good for opioids, 80% of the victims of fatalities being white non-Hispanics, should also be good for other hard narcotics, where 67% of the people in prison are African American or Hispanic. What we have now there is a sort of a Dred Scott division of authority. So we're either going to have more drug prisoners or a lot fewer in the near future, or face what is obvious and racially problematic. I vote for a lot less prisoners. Okay. 3 little things, and then I'll let us all go. Do I have a statistical target for all the maximum reviews? Nah, because you see, those statistical numbers are adding up 51 different systems, and while you can do that in the aggregate for some purposes, you are never talking about governmental policy there. My best guess is 350 per 100,000 per year is probably where we're going unless we make big changes. But the first thing we've got to do, and we learned this from California, is stop just counting the prison numbers alone. The real numbers we should use in each state are people who are locked up, whether that's a local or state facility. That's simply arbitrary. So what we need is not only less locking up, but better statistics on how to count it. Who gets blamed? And here I think that John Pfaff misread the parable of Zimring and the coyotes. Chapter 8 in this book manuscript is trying to say that the blame for this peculiar explosion that we have encountered does not belong only to prosecutors, because, and here was where the coyotes came in, that's like saying when the coyotes eat your lambs because you didn't build a fence around, that it's all the coyotes' fault. Prosecutors go into the prosecution business because they think that punishment makes sense. Chapter 8 quotes a wonderful survey of Canadian prosecutors. All of them who express an opinion either say, well, penalties are about right, or almost 2/3 of them, they're not severe enough. And the impact of that over 40 years in Canada was that the imprisonment rate went down because it wasn't the prosecutor's job in Canada. The problem here is that we have allowed punishment setting to be a prosecutor's job. That's not the fault of the coyote. That's the farmer's fault. Fellow farmers, get your law degrees. The last point has to do not with mass incarceration, but with its effects. Because we've learned a very important lesson, a lesson that should be true for opioids, a lesson that should be true for non-fatal assaults, where people are going to prison 17-fold the 1970 Act. It's not just that millions of people going to prison have been a social bad. It is also that it hasn't solved any of our problems. Retributive justice for sex offenders and assault situations where people know each other and are going to continue to live with each other is a community-based idea. Opioid treatment is a preventive and public health-based treatment. One of the things that should make us enthusiastic, not for diversion from the criminal justice system, but for other systems having priorities, is that one of the things that America has learned all too well over the last 50 years is what the criminal law can't do. End of sermon.
Frank, before you end for today, we have a few questions.
I hope I have a few answers.
Yeah, we'll see. First one, to what degree do you believe that at least some of the punitive turn we took in the 1970s was a political backlash against the Civil Rights Act and the expansion of procedural rights for criminal suspects and defendants under the Warren Court?
Well, let's start with the Warren Court because that has some scholarly support in Bill Stuntz's book on the 70s. And that's something that lawyers might get mad about. And my account of the increase in imprisonment features local governmental lawyers. So that makes a little bit more sense than the general reaction to civil rights. If it was the general reaction to civil rights, you would have expected that would be much more important than in Alabama than in Minnesota and in Florida than Michigan. And when everything goes up at the same time, it suggests that that probably isn't as a regional phenomenon a good explanation. What about the explanation of the Warren Court things? The problem with the Stuntz explanation by itself is that what that would explain is an effort in plea bargaining to neutralize the advantages that occur because of these expansions. It would emphasize plea bargaining, but what it would do is only leave the defendant in the same position punishment-wise that he would have been in if he had gotten convicted and used his procedural rights. If all those procedural rights are being waived, you would expect an equilibrium in imprisonment. So the question is, how can that lead to a many 100% increase from the base? I do understand that procedural advantages can be overrated as a defense opportunity, but how they can become that major a disadvantage at that scale, again, kind of doesn't seem persuasive.
Okay, next question. What about the effect of the way that police are trained? For example, use of routine traffic stops to search for other crimes, big upsurges in misdemeanor arrests, stop and frisk, etc.
Well, look, there were large increases in arrest in many of the periods over the mass incarceration period. But they were only large when you don't compare them to these outcomes. And if you're talking about the number of serious crime arrests of people over 18 who are likely to go to prison, it never increased much. And it started dropping back as early as the mid-70s, then going up from the mid-80s to the early 90s, and then dropping like a stone as imprisonment rates kept marching up. so that the periodicity of the likely independent variable doesn't fit with the outcomes of the proposed dependent variable. Now, the problem with that is that I can keep demonstrating what would be implausible as a cause. But then when we get to the punchline, okay, what was it? There are only very minor explanations, elements left.
Okay, third question that we have from the audience. To what extent does the rise in incarceration correlate with the growth of the sensationalizing media? And what implications does this have for the modern viral social media milieu? Okay, for creating new moral panics and calls to do something?
Well, that would be a wonderful explanation if the United States were the only nation on earth. But the problem we're going to have there is you should see the media in Canada and France and England. Have you read some of the English tabloid newspapers? The royal family has. And all during this period, when you have the independent variable happening all around us, we're the only place that has this effect. It seems quite unlikely. Usually, we're very happy about American uniqueness, not in this department.
Okay, those are the written questions I have from the audience. Is there anyone with I mean, I have a great, did I see a hand? Yes.
This is just very general and maybe kind of follows the last question discussion a little. It just strikes me powerfully how the timeline you set out of the rise and finally peaking, at least, of mass incarceration just maps sort of the rise of neoliberalism almost perfectly. And I just wondered if you had any thoughts about sort of how this example fits within that wider pattern of what reshaped American society, culture, media, government.
Well, again, these are things that have happened in the developed world generally. And the problem with any explanation for the American penal growth is that it's going to have to be singular, at least in its impact in one country and not in others. The first chapter of this book begins with two graphs, and the chapter is called An American Surprise. The first graph is 1970, and what it shows is that the United States is at, when you compare it to 7 other developed nations, maybe a little higher, maybe 6% higher than Canada. And it's about 18% higher than the United Kingdom, and about 20% higher than France. When you then look at 2010, the United States is between 3 and 9 times the magnitude of everybody else in the chart. And so the question that you ask your students on that second chart is, who's in second place? And there is one country that's a little bit higher than the third and fourth and fifth. But the real answer to the question of who's in second place is nobody. because there is a fourfold difference between the United States and every other country. So we have to look for singular American causes. But the issue then is they are pretty trivial for explaining that massive a change.
Yes, towards the back.
When you put it that way, the thing I think about is access to firearms. I mean, all those other countries don't have the access to firearms we have here.
Well, except for the fact there that only 4% of our crimes involve firearms. So the fact that we're locking up the people from the other 96% of those arrests would be one problem with that. There was a period when handgun ownership rates went way up and homicide rates went up with them, but that period was from 1964 to about 1970 or 73. And so that was before the big thing started. Then there was relative for handguns, which are the crimes involved in crimes, the guns involved in most violent crime. There wasn't great growth in household ownership. And again, literally 96% of the offenses, and probably over 90% of the offenses that led, we have to just take larceny off that, to real chances of incarceration, didn't involve guns. So it's an American difference, but it's not a difference that's linked to this period specifically. And it just doesn't have the scale to quite launch a good explanation.
Okay.
But
Yes.
just tying into that, but do you see a change in attitude, how the possession of firearms, the violence, that attachment people have? Because even the most violent acting people now aren't necessarily people who use guns, but it's associated with maybe a change. The Dirty Harry era of, even Quentin Tarantino, that has become such an American way of life, is
Well,
that it's a violent world and we've got to lock people away. This is our solution. Other than shooting them, we're going to lock them away because we're mad.
well, it's hard to tie that specifically to guns, to go back to the previous question. The other point I want to make as we're coming to the end of the day is that I never thought that I'd have to fly from San Francisco to Minneapolis to hear that suggestion. If there is a nonviolent city that I visit, even when it's chilly, I would have thought it's here.
And we have a low incarceration rate.
Okay.
Okay, well, I think that brings us to a close of the day on schedule. We're 2 minutes ahead. So Frank, all participants, thank you greatly. It's been exhilarating. Good day.
Well, thank you.